this statement must be completed. This statement must be completed every time the suspect is interviewed, irrespective of whether the suspect is arrested or not.
Zonke isikhathi umsolo uma kufanele ukhulume naye kufanele lesi statement sigcwaliswe. Le statement ke kufanele ukuthi sifanele sigcwaliswe ngazo zonke izikhathi lapho ke umsolo ukukhulunywa naye. Kungabhekiwe ukuthi umsolo useboshiwe noma akakaboshwa.
Paragraph B.
Paragraph ya boraro.
Paragraph B.
B.
Yes.
The member who conducts the interview with the suspect is to complete the statement fully in the presence of the suspect.
Kuthiwa ke ozobe khuluma ke nomsolwa kufanele agcwalise ngokuphelele istatement lesi phambi kukamsolwa.
Okay. Paragraph C.
Paragraph C.
If there is not enough space on any of the pages, the member must continue on a separate follow page. This follow must be signed by a member, suspect, interpreter, and the commission of oath, and must be attached to the statement.
Lana ke uma ingekho indawo eyanele ekhasini iphasa lifanele liqhubeke libhale kwelinye ikhasi leli khasi lifanele lisayindwe futhi ilona liphoyisa umsolwa utoliki futhi ke kube ne commissioner of oaths and futhi lifanele linamathiselwe ku statement.
Paragraph D.
Paragraph D.
The commissioner of oath must sign on every page of the statement.
Kuthiwa ke ucommissioner of oaths kufanele asayine wonke amakhasi statement.
Yes. Paragraph.
The commissioner of oath must sign on every page of the statement. If the suspect is a child below the age of 18, the parent, guardian, an appropriate adult must sign every page of the statement.
Uma kuwukuthi ke umsolwa useyingane engaphansi kweminyaka e-18 umzali noma omgcinayo noma ke umuntu omdala okhona ufanele asayine wonke amakhasi estatement.
As a good please, my lord, sorry to interrupt my learned friend. The state objects against this line of cross-examination by my learned friend. Firstly, we don't see what the relevance of this cross-examination is. Secondly, the witness said yesterday that the interview on the 17th was not a warning statement. And if one looks at what the exercise that my learned friend is busy with, this regards a warning statement, unless if my learned friend intends on canvassing a warning statement of accused accused number 2 with the witness. But if one looks at paragraph 1, it states clearly there that this form is applicable in the case of a warning statement, and that in that case the station commander must consult with the prosecutor. So whatever follows, my lord, is subject to the obtaining of a warning statement and not an interview that the witness has testified about.
Yes, ma'am.
Thank you, my lord. My lord, I think I've clarified this yesterday, my lord.
Not clarified again because Mr. Balo is now objecting.
Yes.
Do you remember my comments yesterday?
Yes, ma'am.
Yes.
My lord, I am not referring the witness to this paragraph because I'm saying that this document was signed or completed by any of the accused.
Fine. What is that document?
It is a warning statement, my lord. And
Okay, fine. Accordingly,
it's the instructions that are given, yes.
when one wants to take a warning statement,
For the police officer to record when he's interviewing the suspect. my lord.
is it for an interview or for the taking of a warning statement?
It is for an interview, my lord. That's why I read paragraph 2, because
Okay,
it says the
fine.
member, paragraph B, my lord. It says,
Let's start from the beginning. What is that document for? Because Mr. Baloyi says it precedes the taking of a warning statement, and you are saying it's for an interview.
my lord, if I can just repeat myself, my lord, yesterday the witness testified that they were interviewing the suspect in the
Right, fine.
courtroom.
Yes, yes.
Then my question was, my lord, was it recorded? Then I said, where was it recorded? Then I went back to this form to say, this form says the member who conducts the interview with the suspect has to complete this statement fully in the presence of the suspect. And
Okay.
paragraph A, my lord, says, irrespective of whether the suspect has been arrested or not. In other words, my lord, whenever there is an interview between the police and the suspect, that interview has to be recorded because there are allegations, there are constitutional rights that are explained by the police officers at that time.
Fine. And this form, what is it for? The very form. Is it for an interview?
It's for the statement regarding interview with suspect. It's written clearly on the instructions, my lord. In statement regarding interview with the suspect.
Yes, Mr. Baloyi.
And as a court, please, my lord, this is where, with the greatest of respect, we submit that my learned friend misses the point.
Why don't you bring, okay, you know what?
Yes.
Just bring me the law.
Yes.
Okay, because you're at different
Yes.
poles.
Yes,
Can you
but-
give me the authority you're relying on?
Yes.
And please, Ms. Mshololo, give me the authority you're relying on.
Yes, but-
Can you adjourn for that?
Yes, but can we just make this one point before we adjourn, my lord? Just this one point. If one looks at paragraph A, it says clearly, the station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement.
So the prosecutor must also be involved.
Yes, and this is the emphasis must fall on warning statement. The station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement of the
taken.
suspect be obtained. And secondly, it says in every such case, in other words, in every such case where a warning statement is required. It doesn't refer to any interview with the suspect. And my learned friend is now opines that in every instance when a police officer conducts an interview with the suspects, then this process must be followed. It's only in the case of a warning statement.
And that, as I understand the law, that precedes the charging
Yes.
of the suspect.
In-
Okay, can you get me the law so that we don't argue in a vacuum?
As the court.
How long do you want me to adjourn?
My lord, maybe 30 minutes because I've already have the authorities. I'll just make the copies.
Do you have any authorities for yourself?
we still have to look up, but it shouldn't take that long.
Okay, 45 minutes. Yeah, what are we busy
were
with?
busy with a questioning or interview that Sergeant Mohani conducted with a suspect.
Yes,
And
in the boardroom.
yes, in the boardroom. In other words, we're not busy with the taking of a warning statement,
Yeah.
but just maybe an interview, an informal interview that a police officer had with a suspect.
Is that the background to the
Yes.
issue?
Indeed, ma'am.
Yes, Ms. Mshololo, let me understand you. What are we dealing with?
My lord, we are dealing with the interview which took place between the suspect and the witness at the boardroom.
Right?
Where,
It's an interview.
it's an interview.
Yeah, what about it?
Yes, then my lord, my submission is that because the witness said he explained the rights, he explained the allegations, and the accused responded. Therefore, that interview ought to have been recorded.
Right?
Yes, my lord, that's
If
where
it's
we
not
are.
recorded,
It's my submission, my lord, the court can make a ruling.
yeah, fine. Is that what you are dealing with, and is that what your colleague is dealing with?
That's what.
Now, how does this form come into play?
My lord,
This form which you say the court must peruse.
it's because, my lord, this form says statement regarding interview with the suspect. Hence, I referred this witness to that form. And it says, my lord, on the first page, statement regarding interview with suspect, paragraph 1, my lord.
Oh, you're reading paragraph 1 where it says the form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue
Yes.
on a folio attached to the folio of that page.
Yes.
And folios must be signed by the suspect, the interpreter.
Yes.
So you are saying this form is applicable, in other words.
My lord, that's my respectful submission. my
Okay,
lord,
you want me
say-
to rule on that?
To say during that interview,
It must be signed, the form must be signed according to you.
it must be recorded, my lord.
Yeah.
Although, my lord, I am not saying that the witness was bound to use this as its.
No, let's have, the
As-
submission is that it must be filled, this form, or what is your submission?
Yes, it must be.
It
My lord,
must be filled.
My lord, can I just refer this honorable court to just one judgment?
Which one is
I'll be
that?
quick. I'll be quick, my lord. I won't waste the court's time.
Which judgment is that?
It's the Henry Foster and the Minister of Safety and Security. It's judgment by,
Others.
yes.
I've read this judgment.
Yes, yes.
It's about damages,
Yes, my lord.
unlawful arrest, and the assault of a suspect who subsequently, obviously, the charges were withdrawn because there was not sufficient evidence.
Yes, my lord. But there is a principle that I want to bring it to the attention
Which,
of this
yeah, okay,
court.
fine, bring it. Which principle is that?
Thank you, my lord. On page 23, paragraph 28.
Wait, I'm going there.
Yes,
Page. Wait.
page 23.
Wait. Page 23.
Yes. Page 23. It's paragraph 28, my lord.
Paragraph 28.
Yes.
Yes, put it on record.
Yes, my lord. Paragraph 28, under warning statements, my lord, it says, express provision is made in every warning statement in this court's jurisdiction for the completion of a warning statement each and every time that a suspect is interviewed. Paragraph 29, the constitutional protection provided for in terms of section 35 of the Constitution to arrestees is embodied in this principle. There is no justification for any interview with a suspect who has been arrested or called in for questioning to take place without a warning statement being completed. Paragraph 30, my lord. The very term warning statement indicates that the person is a suspect and has been warned of his rights, and in particular his rights to remain silent before any such interview may take place. Paragraph 31, it serves no purpose to attempt to recognize that an arrestee is not obliged to say anything, make any admissions, or answer any questions unless he is specifically forewarned of these rights and signs in the warning statement that he has been so forewarned prior to any interview or interrogation taking place. My Lord, I will skip all these paragraphs and then just go to paragraph 33. Oh, sorry, my Lord, I have not finished. Yeah, I'll skip this. And then paragraph 34, my Lord, the next page, on page 24, which says, it was startling to hear that both defendants' witnesses, who were experienced policemen, believed that they were entitled to question a suspect or arrestee at any time that they wish to do so without being compelled to complete a warning statement. And the last reference, my Lord, is just one paragraph before it goes to, I'll summarize it, my Lord, paragraph 38.2. Paragraph 38.2, I'll be quick, my Lord, wherein it refers to the warning statement which is headed, statement regarding interview with suspect. Paragraph 38.2, my Lord. 38.2.
Yeah.
Yes, my Lord. It says, the warning statement which is headed, statement regarding interview with suspect. It is referred to as SAP S3M document and embodies 12 pages on the cover and on every first page under the insignia of the South African Police Statement. The statement regarding interview with the suspect. This form must be completed every time the suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on the portfolio and attach the portfolio to that page. Folios must be signed by the suspect, interpreter, deponent, and commissioner of oaths. Thereafter, my Lord, on the same paragraph, the interviewing police officer is required to record that he has informed the suspect of the allegations, that he is investigating against him, her or her, to ensure that he understands the allegations. There are numerous introductory paragraphs and forms that require completion. The suspect is entitled to make, or if he wishes to do so, whereafter both suspects and the member of the SAPS are required to sign the document. All of the constitutional safeguards provided for in respect of arrest, accused, and detained person are contained herein, and the document sets out each and every step that must be followed in completion thereof. Paragraph, this is the second last paragraph I'm referring this court to, my Lord. There is no basis in law on paragraph 19, my Lord. Paragraph 39. Yes, paragraph 39. There is no basis in law or fact to conduct any type of an interview or interrogation without completing such a document. Any attempt to do so will render the arrest and detention of the suspect not only unconstitutional but unlawful. I am fortified in my view that the arrest and subsequent detention of the plaintiff in this matter was not, this is for the judgment of this case, my Lord. But can I just read it to complete the paragraph? The matter was not only unconstitutional but unlawfully because the defendant's witnesses testified under oath that they were of the view that they were entitled to interview and interrogate the plaintiff without having completed such a document. This can never be the case. The express term of the document make it abundantly clear that when a suspect signs them, he or she does so in order to acknowledge that he has been notified of his or her rights and he understands them. Paragraph 40, the practice whereby these documents are completed merely satisfies the prosecutor that the suspect may now be taken to court is to be frowned upon and not condoned by this court.
And it's a single judge. It's a single judge who says that.
Yeah.
Oh, it is.
Yes, ma'am. It seems that notice in terms of the Constitution is completed before the person is accepted into the cells, but merely as formality and for no other purpose. The warning statement is also completed merely as a formality that is required for administrative purposes or as part of the paperwork, but not for the intended purposes. As previously stated, mere lip service is paid to the rights embodied in the Constitution as detailed in the documents. They are significant in determining whether an arrest or subsequent detention are lawful or not, can never be overemphasized. My submission, my lord, to this court is that this form, it does not, my lord, necessarily say it must be completed when the suspect is charged. But this form says, as I've read it into the record, it must be completed whenever there is an interview between
Who must complete it?
It must be completed by the person interviewing the suspect.
By the police person?
By the police person, yes, my lord. Interviewing the suspect. If I can go further, it even says the number of the people who were present during the interview should also be recorded. My lord.
Have you read Preller's remarks?
No, my lord, those are my submissions.
Yeah, fine. No. I want you to
Yes.
listen to what Preller said, because you brought this judgment.
Yes, my lord.
This was a 3-bench judgment. Preller was the senior judge, Manamela acting, and Kumalo was the other judge. But this is what Preller said. Manamela was the scribe, and the 2 judges overruled him. I have had the benefit of the judgment of my learned brother, but reluctantly find myself unable to agree with the conclusion to which he has come. The evidence was comprehensively dealt with in the judgment of the court of co, and there is no need to repeat it here. Suffice it to say that there were no misdirections in the judgment, and nor did counsel argue to the contrary. The main problem in this appeal arose from the remarks perhaps inadvertently made by the court of co in its judgment on the admissibility of certain crimes as to his co-accused. It is therefore clear that the court was well aware of the constitutional rights of the 5 accused and the discretionary nature of the exclusionary rule contained in section 35(5) of the Constitution. The subsection reads, evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise detrimental to the administration of justice. The prohibition is against the admission of evidence obtained by a process that violates the constitutional rights of the accused. That means only that if the accused person has, for example, been tortured or assaulted in order to force information from him, that information must be excluded. No finding to that effect was made in the judgment. The rule does not mean that any improper conduct, even if unconnected to the making of the statement, results in the exclusion of the evidence. That would be an application of the controversial rigid exclusionary rule of the North American law. I think it's State versus Ross, that case. The trial court is the primary trier of fact, and this court can only interfere with the finding if we are satisfied that it is wrong. A vague suspicion that all was not kosher and is not enough. Unfortunately, we don't know how exactly what the learned judge had in mind with this remark, but the fact is that he considered every detail of the relevant evidence very carefully and came to the conclusion that the evidence should be admitted. In the process, he expressly rejected the contentions of the appellants that they had been tortured, as well as their evidence that they had made the statement and done the pointing out under the... Somebody interfered with it. Where's the 4th page here? Somebody removed it. Is that page 4? Can I have page 4? Thank you. Yeah. And then paragraph 92 reads, it's page 4. One of the main contentions still read page 19. Paragraph 88, sorry. It says, it is not necessary to set out the evidence adduced in the court below, as Manamela AJ has done in some detail in his judgment. My view and position in the matter is informed by the approach advocated by the court in Take and Safe Trading CC versus Standard Bank of South Africa 2004-1 or South Africa SA 597 SCA 2004, where it was stated, a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake made by the other side, and the judge's position in a criminal trial is not merely that of an umpire to see that the rules of the games are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. Every person is ensured a right to fair treatment as a suspect and a fair trial as an accused by the Constitution. Section 35 commands that arrest processes and criminal trials be conducted in accordance with the basic principles of justice and fairness. To guarantee the protection, subsection 5 thereof makes provision for the exclusion of evidence that has been procured in a manner that violates any right of the Bill of Rights, if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. To ensure a fair trial, a presiding officer or judge may therefore only consider evidence obtained legitimately to establish whether or not an accused is guilty. However, in terms of subsection 5, if the admission of the evidence would not render the trial unfair or detrimental to the administration of justice, even though it might have been in a manner obtained in a manner that violates a Bill of Rights, it will not necessarily be excluded. Therefore, not every violation of a right protected by the Bill of Rights leads to exclusion. See in this regard, S versus Ndlovu and others, 2002, SCA, ZACA 70, 2002, 2 SACR 325 SCA. The section does not couple the discretion to exclude directly to the violation of a right as argued on behalf of the applicant, but to the consequential unfair trial. Therefore, the jurisdictional prerequisites for the exercise of the discretion to exclude is a requirement of unfairness or the prejudice to the administration of justice. What the subsection accords are fundamental and absolute is the right to a fair trial. In S versus Tandwa, 207 SCA 34 RSC 8, Cameron 116 observed the pre-constitutional approach to the exclusion of improperly obtained evidence to be in these terms. The noble feature of the constitutional specific exclusionary provision is that it does not provide for automatic exclusion of unconstitutionally obtained evidence. Evidence must be excluded only if A, it renders the trial unfair, B, otherwise detrimental to the administration of justice. This entails that admitting the impugned evidence could damage the administration of justice in ways that could leave the fairness of the trial intact, but where admitting the evidence renders the trial itself unfair, the administration of justice is always damaged. Differently put, evidence must be excluded in all cases where the admission is detrimental to the administration of justice, excluding the subset of cases where it renders the trial unfair. The provision plainly envisages cases where evidence should be excluded for broad public policy reasons beyond fairness and individual fairness and of the accused. Kachalia, in S versus Mtombo, said the following: public policy in this context is concerned not only to ensure that the guilty are held accountable, it also is concerned with the propriety of the conduct of investigating and prosecutorial agencies in securing evidence against criminal suspects. It involves considering the nature of the violation and the impact that evidence obtained as a result thereof will have, not only on a particular case, but also on the integrity of the administration of justice in the long term. Public policy, therefore, sets itself firmly against admitting evidence obtained in deliberate or flagrant violation of the Constitution. If, on the other hand, the conduct of the police is reasonable and justifiable, the evidence is less likely to be excluded, even if obtained through an infringement of the Constitution. This accords with what Krichler said in the case of K versus Attorney General of the Transvaal, 1996 Constitutional Court case, where it says sometimes even unconstitutionally obtained evidence, because of the demands of public policy and the demands of fairness in the administration of justice, may be admitted, even if you're aware of the case.
Yes, ma'am.
So this case of Hodis, it's not the be it and the be all.
As the court is.
I've quoted you two constitutional cases
As the
where they
court-
say even unconstitutionally obtained evidence. Do you have that? Hello? Key, Attorney General of the Transvaal, let's read it so that everybody knows it. Right? Do you have it?
Yeah, I'm just finding it quickly, my lord.
Yeah, just find it. Yeah, you've got Mr. Computer. So the case has to delve into the intricacies of public policy, the fairness, etc. And this, according to me, this form has got no force of law. Do you agree with it?
As the court pleases.
Yeah, it has no force of law. It's a guideline. But I'm not stopping you from arguing. You can argue that. I'm just saying preliminary. Where's that case?
Oh, my learned friend is finding it.
No, man, just find it. Because people, when they read the Constitution, they all say if the evidence is unconstitutionally acquired, therefore it is not admissible. You further go and examine the phenomena and the exigency under which that evidence has been acquired, the demands of public policy, the demands of fairness, the tension between the demands of the police to maintain law and order and the perceptions of the public regarding the application of fairness. After that, we can conclude whatever cross-examination you
May
want.
other counsels be given opportunity to make submissions?
Yes,
for the
yes,
ruling?
no, everybody,
Thank you, ma'am.
everybody. So Hodes has got a point, but the point is, as I understand the evidence of this witness, predicated on that interview, amongst other interviews, he repaired to Carltonville to go and further investigate. That's what he says, not me. When he got to Carltonville, Benida came and they went to see the personnel manager, and the personnel manager made a statement to them
My Lord, can other councils respond at this
Yeah.
stage
No, we're
before
going to
the
read this.
ruling is made?
We're going to read this, and then everybody is entitled to
Thank you.
respond.
As the court pleases.
Sorry, Rose, let's go and fetch that case. 1996, Attorney General of the Transvaal. Just go check him out. You have it in your computer. Yeah, P. This is KEY. This is Attorney General of the Transvaal, 1996 Constitutional Court. Kerso. You got it? That one. Yeah, that's the one. Sorry. No, yeah, I forgot class. My registrar found the law.
Yes, it's paragraph 23 of the judgment.
Yeah, paragraph 23.
It says at times fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Yeah. Go on.
Well, and it says if the evidence to which applicant objects is tendered in criminal proceedings against him, he will be entitled at that stage to raise objections to its admissibility. It will then be for the trial judge to decide whether the circumstances are such that fairness requires the evidence to be excluded. It follows that the applicant is not entitled to an order from this court in these proceedings, that the evidence secured as a result of the searches and seizures will be inadmissible in criminal proceedings against him. Yeah, I don't think the...
Yeah, read that tension. Why critical reasons like that?
Oh, okay.
Because some of us may not know it. He talks about the tension.
There's paragraph 13. Says in any democratic criminal justice system,
Yes,
there is a tension between, on the one hand,
that's it.
the public interest in bringing criminals to book,
Right?
and on the other hand, the equally great public interest in ensuring that justice is manifestly done to all, even though suspected of conduct which would put them beyond the pale. To be sure, a prominent feature of that tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures and courts to prevent or curtail excessive zeal by the state agencies in the prevention, investigation, or prosecution of crime. But none of that means sympathy for crime and its perpetrators, nor does it mean a predilection for technical niceties
Stratagems.
and ingenious legal stratagems. What the Constitution demands is that the accused be given a fair trial. Ultimately, as it was held in Ferreira versus Levine, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take that decision. At times, fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Okay, yes, Mr. Mnisi. Mr. Mngomezulu, sorry. Any submissions?
Court, please. My Lord, my submission, firstly, I would agree with the principle that each case is decided on its own merits. under the circumstances of this exercise or this discussion is that when we look at the interview that was conducted or was held in the boardroom, it was held under a different pretext from the officer. He was booked out from the police cells to the boardroom under a very wrong case, case 163 of 10/2018. When an interview is carried in terms of a docket that is the accused is now facing on the charges of a case docket under 636. My Lord, the unfair part of the principle in the doctrine of fairness lies on the aspect that if a right was explained to the accused, it was in respect of case number 163 and changing tune when they are in the boardroom. So now the accused is no longer, as per the evidence of there's no evidence before this honorable court that accused was interviewed in terms of the Onongoma case. But all that we know before this honorable court is that an interview was conducted relating to the whereabouts of accused number 2 on the date of the 26th of October 2014. Is that fair for the accused in the course of administering justice to be taken by surprise to say, this is what we arrested you for, but now we are subjected now to these particular allegations. Please provide us. To what extent did the rights were explained, especially under case number 636? Second fold of my submission is that it's based on the evidence that is before this honorable court that at all material times when the accused number 2 is booked in and out, there's no indication, there's no entry that he was subjected to an investigation under case number 636. So that would tantamount to unfairness, and that will jeopardize to proper functioning of justice system. In this regard, as the facts are as matters are decided on their own merits, it is my humble submission that accused number 2, they should have actually gave him a clinch or an information. He's the one that he received an information earlier that he is involved in the murder case of Senzo Meyiwa. But when he is booked out, when the rights are read in terms of Exhibit LL, they are read under a very wrong case number.
Okay, thanks.
That's my submission.
Yes, Mr. Nisi?
As it is the court, may.
Yes, no problem.
As it is the court, Madam. Madam, I think there's a bit of a confliction.
Conflation.
A conflation of issues.
Yeah, I mentioned them.
Yes, Madam. When this issue was raised by my colleague Advocate Mshololo, and indicated that there is authority, or in fact, each time the suspect is being interviewed, that interview needs to be recorded. Then my colleague for the state stood up and said, but that's not always the case. Then the court also got in and said, as far as the court understands the process, is that a warning statement is only supposed to be filled in as and when the suspect is being charged for him to be prepared for court. My colleague further insisted that, but that is actually not exactly the case. That is when this commotion or this argument actually started. In order to satisfy himself, then the court invited all parties to bring authority before court to support their submission in respect of what they believe in. The defense, my colleague, Advocate Mshololo, brought a judgment that specifically addresses the issue that the court said, bring judgment, bring an authority to convince me. We were expecting the state as well to bring a judgment that will go contrary to what the judgment that has been brought by my colleague is saying. The state hasn't.
Okay, fine.
Instead, what is happening now, my lord, we are trying to confuse two issues that are very distinct. Whether or not it is in the interest of justice that evidence that is sometimes unconstitutionally obtained should be obtained or what. But this is not the crux of the investigation as to why we actually had to come here. In the judgment of Hodes SC, it's very clear. The statements regarding with the interview with the suspect, it's very clear. Each time there's an interview with the suspect, whether or not that suspect is arrested, this document must be filled in with no exceptions. I won't go back and refer to what my colleague has said.
Yeah, I've heard you.
But now, there's also a referral to the case of, to what the Honorable Judge Prela said. These two cases are totally distinguishable, because in the Prela case, my lord, it was not about whether or not each time that a suspect has been interviewed, this document 3M in brackets, small letter m, must be filled in. It was only a determination on whether or not the statements that were used in the decision of this case should be used against the accused person in this case or what. So these two cases are totally distinguishable. As I am standing here, madam, I am still expecting the state to present to the court an authority that says no, it's still fine for a suspect to be interviewed without having to fill this SAP 3M in bracket M. The state is not
Okay, I've heard
forwarding such information. So basically, we are not saying, my lord, that the court should make a decision and now.
I'm not going to make. Hey, I'm not confused. I'm not going to make a decision now. You're arguing the law. I'm going to make a decision at the end of the case. Don't go about saying, hey, the judge lady.
That is what
I'm listening to the principle of the law. And the decision which I will make will be predicated in the sense that I gave all of you a chance for the input of the very issue which is being debated in this case. But I'm not making a finding, I'm not making a ruling, never.
Yes, my lord, that is basically would have been my next point.
That I'm going to make a ruling.
And no, I intend to say, my lord, that when my colleague, Advocate Mshololo, raised the issue of the interview with the suspect in the boardroom and whether or not this form was filled, it should be something that should be, my colleague should actually be allowed to proceed with that form of cross-examination. It will then only after all the evidence at the end of it all has been heard.
I said
then
that,
the court
ask your colleague, I said that to her. Didn't I say that to you, Ma'am Sholol? That I'm not stopping you from going ahead with the strategy of the cross-examination you are course on. Didn't I say that?
My lord, the problem is that when
All I said, do you admit that this form doesn't have statutory application? That's all. And you said no. But I never said to you, stop your cross-examination. Never. I will never say that to any counsel.
My lord, after I've been granted that leave, my lord, the state objected.
No, but I decide whether you continue or not Mr. Baloyi. Okay.
The state objected, then the court said we must make submissions.
Yeah.
That's where we are in, my lord.
Yeah, fine.
Thank you.
Yes, Mr. Numalo. Oh, are you still on?
No, I just wanted to wrap up, my lord.
Oh, I said, okay.
Therefore, my lord, it will be very precarious. Actually, it will be a precarious procedure to, at this point, decide this thing as if it is final.
Who's going to decide it? I told you I'm going to decide at the end of the case.
The reason why I'm saying this, my lord, It's because I hear already there are authorities that are being referred to which do not specifically deal pertinently with the issue that the court has raised.
Yeah, in other words, you and Mr. Mshololo and Mamalo and Mr. Mngomezulu, Baloyi, at the end of the case, they're still going to have to argue
As it please the court, madam.
about the admissibility of these statements and confession and pointing out how much.
And more particularly with regard to that interview
Yes.
that was held in the
That's
boardroom,
it. You're still
where
going to
this form
argue.
was not fit. Thank you, my lord.
At this
That would be
stage-
my submission.
I had two contrasting legal submissions.
Yes,
That's all.
thank you, madam.
All right. Yes, Mr. Mamalo. Hey, my God. And I may just add, other judges just keep quiet. They keep quiet and then yes sir, yes sir, yes sir, and thereafter they come with a decision. I don't do that.
As it please the court. Yes, that's
I don't do that.
The court should not only be a passive umpire.
Yes,
as it
yes.
please the court.
Yes, Mr. Mamalo.
My lord, my starting point will be that it is not enough for the police to use the SAP 14A, because we've been hearing that the SAP 14A was used, that is before and after the accused, that is accused number 2, was at the boardroom.
That's a guideline.
Yeah, as a guideline. I'll re-emphasize and follow the decision of Holtz SC to the effect that whenever the interview is conducted with the suspect, it must be recorded, and the statement regarding interview with suspect form must be used. I'm having the understanding, my lord, that if that is not followed, then it violates the accused rights in terms of Section 35 of the Constitution, and therefore, in terms of Section 35(5) of the Constitution, it stipulates that evidence obtained in violation of the accused rights must be excluded if that, or the admission of that evidence will render the administration of justice into disrepute. This form gives an obligation. It's an obligation to the police to say whenever the interview is conducted with suspect, this form must be used.
Yeah, I agree with you. You see, it's incumbent upon you as advocates of this court to make representations to the Minister of Justice, to pass regulations
Yes.
addressing the very exigence.
Yes.
Manje antet niyakhuluma nje.
It looks like there will be a number of representations.
Yes, you have a right
In this
as that's how the law develops.
Yes.
When there's a lacuna in the law, the persons who practice in this court must take it upon themselves to address that lacuna so that the Minister of Justice, Lamula, must address that. Because it's going to recur. That's why you have 9 provinces and we get 9 different decisions in all the 9 provinces. Okay.
Thank you. Thank you.
Mr. Msholo, you are continuing.
No.
You are continuing with your cross-examination.
No, my lord, we are still waiting for this.
No, you are continuing with your cross-examination. Is that not so?
Yes.
Yeah, now we listen to Ubaloyi. Remember I said I'm not deciding the issue now. I'm going to listen and hear all of you, what you say. So Baloyi must say whatever he wants to say. Thereafter you continue with your
Yes,
cross-examination.
That's the
Okay.
court business, my lord.
Is it so difficult, madam?
That's the court business, my lord.
Yeah. Yes, Mr. Baloyi.
Mr. Court, please, my lord, we just want to come from a slightly different angle, and we raise an objection based on purely issue of evidence, of relevance. You know, my lord, we objected on the basis that the questioning is not relevant in the sense that my learned friend was pursuing a line of questioning that says the accused number 2 made a statement. From the evidence that has been given by the witness, I'm not even sure if one can put it as high as that to say that the accused made a statement. What we have before court, my lord, is
made a denial.
Yes, it's evidenced by Sergeant Mohani that says we convened in the boardroom with the accused. I warned him according to his rights, and I, as a suspect, I informed him what the purpose of the interview was, and the accused gave an explanation. I don't know if one can say that it's a statement. He gives an explanation. He says he doesn't even tell him about the date on which the offense was committed. He says, I'm investigating the case of the death of Mr. Senzo Meyiwa. And the accused then, out of his own volition, says, well, I know about that matter. I read about it in the newspaper. Is that a statement? We submit with the greatest of respect, my lord, that if one looks at the form that my learned friend wishes to use to cross-examine this witness, it refers to some sort of a formal statement. All that Sergeant Mokhan was doing was to offer the accused number 2 the opportunity of an explanation, and he says, I was at work, and that defense is pursued. Suppose, my lord, for one moment, that if the explanation that the accused gave that he was at work, if the cloaking records confirmed his version, that would have been the end of the matter. There would have been no need to pursue the matter any further. It could have never been the intention, and even with the judgment that my learned friend has referred to, that where an accused gives an explanation, that the formal process that my learned friend wants to embark upon, that should be followed. These are just preliminary issues that are aimed at establishing whether a formal statement or a statement should be obtained from the accused at a later stage, and which happened in this case, my lord. After these preliminary processes, a formal statement was obtained, to which the investigating officer will refer to when he testifies. It can never be in the intention of the judgment by Judge Horus to say that in every instance where there's that preliminary inquiry, that this formal process should be embarked upon, that a form should be completed, and the form speaks for itself. It talks about a warning statement. It talks about the involvement of the prosecutor, the station commissioner. We submit with the greatest respect this. It envisages a process where a formal statement is intended to be taken from an accused. And if one looks at a discussion under this topic, it all results under section 217, which deals with the confession. So we submit, my lord, that the intention here with this form and with the process that my learned friends wants to embark upon is, if, or in the case where a statement of some sort has been made. We also want to refer to the judge's rules, my lord. We know that they have, as it were, been taken over or subsumed by the Constitution, but these rules still serve as a guide.
What is that, 1946?
Yes.
1940, yeah.
1931.
41, when
Yes,
I was on the queue to be born.
They were approved at a conference in Cape Town in 1931.
Yeah.
And the writer Himstra describes the purpose as follows. He says, these rules are administrative directives for the guidance of the police force. And he says, the judge's rules are mainly of historical interest because they are longer in effect, their role having to a large extent been taken over by the norms in the Constitution. the following is important. They nevertheless remain general guidelines for the police and the courts for the everyday conduct of police officers in respect of suspects. And in this instance, we want to refer to Rule 5, which says, where a person in custody wishes to volunteer a statement, he should be allowed to make it, but he should first be cautioned. And this is contained in Section 35, which distinguishes between an arrested person and a detained person. And Section 35 states that the person in detention and custody should be informed of the right to remain silent, to be informed promptly of the right to remain silent, and of the consequences of not remaining silent, and not to be compelled to make any confession or admission that could be used in evidence against that person. So if one looks, once again, my lord, this buttresses the point that we are of the view that in this instance, one cannot really say that the accused made a statement, because if one looks at subparagraph C, it says not to be compelled to make any confession or admission that could be used as evidence against that person. And the same is reiterated in Section 35(2) pertaining to a detained person. And in this instance, the detained person also includes a suspect who's in custody, as it was held in the Sibajan case. But to come back to the judge's rule, rule number 8 says the caution to be administered to a person, in other words, that he's got a right to not to make a statement, and what the consequences thereof is or are, says the caution to be administered to a person in custody should be to the following effect. And the rules distinguish between a person who's formally charged and a person who's not formally charged. In the case where a person is formally charged, it says, do you wish to say anything in answer to the charge? You are not obliged to do so, but whatever you say will be taken down in writing and may be used in evidence. And we submit, my lord, that this is what this form caters for. And paragraph B says, where a prisoner volunteers a statement otherwise than on a formal charge. In other words, in this instance that we're busy with, if the accused volunteered a statement, and here the judge's rule refers to a statement, where a prisoner volunteers a statement otherwise than on a formal charge, the warning that should be administered should be to the following effect. Before you say anything, I must tell you that you are not obliged to do so, but whatever you say will be taken down in writing and may be given in evidence. We submit, my lord, that what we are currently seized with it's not a statement, it's just a mere explanation, an alibi that the accused gave that he was at work on the particular day, which was subsequently followed. And we submit, therefore, my lord, that this form that my learned friend wishes to make use of is irrelevant, purely on the basis of evidence, and should not be used.
Yes, thanks. Yes, Mshololo, you can continue.
Should I
My lord,
continue?
Yes.
I see the witnesses.
Oh, okay. You want to talk to Mr. Baloyi?
No, le kgopela go addressa kgoro pele Mamsholo la bolela.
I was asking
Nna le ka
to-
o itshwenya.
I was asking to address the court before the defense asked a question. There is something that is bothering me, my lord.
Okay.
Lekabole.
Maabane kgoro e kgopetše gore ke tle le pampiri ya di-case be re dira maabane.
Yes.
Yesterday, the court asked me to bring a document of cases that we were doing.
So inkantolo ecela ukuthi ize namakhesi la besebenza nawo izo.
Ngikilele tjona ka re leng fupetše.
I brought the documents as the court has asked me.
Ngize nawo ke njengoba bese ngiceliwe.
Ke ngwetse ka mokamelato e be re dira le mabitso a batho ka mogare.
I've written down all the cases that we were doing and the names of the accused.
Ngifale wonke amacala ngasibhala namagama abantu abasolwa.
Ome ke file advocate Baloyi ka envelope.
I also gave it to Advocate Baloyi contained in an envelope.
Bese ngwanika advocate Baloyi ngebilobu.
Ara ke dutse mo re tšere break.
As we were sitting and during the break, my lord,
Njengoba sihleli la sithathe ikhefu.
Ke bone pampiri jo gore e ngwetse confidential e ke le fa yona.
I saw the document. When I handed it over to Mr. Baloyi, it was written confidential.
Ngabe senginike kwaBaloyi ibhaliwe ukuthi ke ngiyemfihlo.
Mara ke bona ba re tšetše titima mo matlhong a batho ba ntši mo.
However, I saw the document now roaming around in court, my lord.
Who else had that document?
Ke mang ye mongwe e leng gore o bile le yona?
Le bone Muzi na e tshwere ba swere ka moka ba ne ba e bala.
I saw Muzi in possession of it and all the accused were reading it.
Ngone umuzi iphethe ngibone nabanye abasolwa beyifunda.
Who gave them that? Do you know?
Le a
Lieutenant?
tseba gore ke mang o ba fileng yona?
A ke tsebe.
Wait, let him have his say. Who gave it to?
Le a tseba gore ba filwe ke bo mang?
Bona banikile.
A ke tsebe gore ba file ke mang.
I do not know who gave it to them, my lord.
Angazi ukuthi banikile ubani.
And bjale ke kwa ke tšhogela dihlatse tša rena tša mo melatong eo.
And now I am being worried, my lord, for our witnesses, especially in those cases.
Manje sengisabela ke abe ofakazi kula macaleni.
And e ke botša kgoro gape melato e mengwe eo e ama baswariwa ba bangwe ka sa bitše ka mabitso.
And some of those cases also affect some of the accused. I would not mention them by names.
Eminye ke le macala thinta abanye abasolwa ngeke ngibabize ngamagama.
Ka gore bjale melato e ka moka o nkga sethunya ka magare ga ona.
And in all these cases, my lord, there are firearms that are involved.
Manje konke ke le macala kunanesibhamu esikhona lapha phakathi.
Batho ba thuntšitšwe,
People were shot,
Kunabantu abadutshulwe.
batho ba utswitšwe,
people were kidnapped,
Kunabantu ababanjwa.
ba bangwe ba threateniša.
and other people were threatened.
Kona ke abasatshiswa.
Bjale be ke tšhogela gore na re hlatse tša ka re tla tsoga re sa phela go sasana.
So I was worried if my witnesses would still be alive tomorrow.
Manje sabela ukuthi ofakazi bami bazobe besaphila yini kusasa.
E ke bolela bjalo go na le di-case number tše dintšhi mo.
As I am saying that, my lord, there are a couple of case numbers there,
Khona ke amacala amaningi ke inombolo zawo esikhona lapho.
And go kgonagala gore ba tsene mo computing system ya rena, computer system ya rena ya SAPS gore ba kgone go kry-a mabitso le di-address tša dihlatse tša rena.
it is possible that they can go into our SAPS computers so that they would get the names and the addresses of our witnesses.
Bangakwazi bangene kuma-computer ethu ase-SAPS ukuthi bakwazi ukuthola amakheli namagama abantu.
Go bolela bjalo a ya gore ke mo phara ka molato. Advocate Mngomezulu o tle le pampile gore o intšhitše mo systemeng ya rena ka case ya Nongoma.
By so saying, I am not accusing Advocate Mngomezulu, but he brought a certain case which he got into our system of a Nongoma case.
Ukuthi sikicala ukuthi Advocate Mngomezulu nephepha ayalikhiphe kule case yethu yakwaNongoma.
E bontšha moswari wa mathomo.
And it shows accused number 1.
Ikhombisa umsolo wokuqala.
And mo godimo motho wa montšheditšang yone ke bone ngwetse Sergeant Mngomezulu a ke tsona ke leloko la ga bona.
On top, it shows that a person that has retrieved that case is Sergeant Mngomezulu. I'm not sure if is that sergeant related to him or not.
Manje laphezulu ubhalwe Sergeant Mngomezulu. Angazi ke noma owakubona.
Bjalo ke kwa ke tšho gore na ba bangwe ba ka se kgone go ntšha information eo ka mokgwa yona e kry-ileng ka gona na.
So thus I am afraid, my lord, that will others not be able to retrieve the same information as he received it as well.
manje sengiyasibuza ukuthi laba abanye ngeke bakwazi yini ukukhipha-ke lo ntwazi ngale ndlela naye alukhiphe ngayo.
Be go bala botsa go rena nako ke tla le pampiri e be ile ya baemedi or e be ile ya baswari bana.
And I would also like to ask, when I brought that document, was it for the defense or was it for the accused?
Ngiyabuza ukuthi njengoba bengilethe le maphepha la abe abamaloya noma abeqondiswe kubasona yini?
It was for the court. Actually, I'm shocked. I'm shocked. Because that document is supposed to be perused by me first. Because I'm aware of the Intelligence Act, that certain documents are classified. I'm aware of that. I've dealt with cases like this in the past. When apartheid was applicable, where you approach a judge in chambers, and the judge makes an order and reads it in chambers to the presiding advocates. But because we are so-called in a new dispensation of transparency, I made it in open court. But that document, or those documents, are not supposed to be seen by anybody except me, first.
Khotla e re imagage go bana ditokomane tse ba di tshwanetse di bonwe ke khotla pele ka lebaka la gore ya tseba gore mo melatong e mongwe o sa le gwa diragala eng gape ga di jwale ke gore re shtere le mo eleng gore re lokologile dilo di kgona go diraga ka tsela e leng gore ga se ka matshwanedi eupia khotla e re ditokomane tse di be di tshwanetse di bonwe ke khotla pele lapile e be le gore e tlatla e di balla baemedi ka bua kantorong ya moatlhodi.
Are you with me?
Hey, ka go ishebe re nya go fetisha mo go tlhaletse gore botse botse.
No.
Pampiri be ile ya go fama.
And I was trying to avoid a situation where in South Africa people and judges are accused of being bought, being captured and all that nonsense.
Khotla e re yona e fitlhetse mo karolong e leng gore e lapile gore di judge le batho ba ka tla ba pharwa ka melato ya gore ba rekilwe go ba bona ba dira bo manager bo borileng.
And I was going to familiarize myself with that information, having regards to the Intelligence Act and protocols.
Khotla e re e be itlotse ya ditokomane tsewe e di bale e lebelle gape le gore e re molao o reng gape le tshireletso yona e re.
And I would have decided what information, having regard to the proceedings here, has to be divulged to the councils here.
Kamera mo we khotla e be itlotse ya sephetho sa gore ke tse di feng tse leng gore di swanetse di fiwe batho go ba baemedi le motšhotšhisi.
Are you with me, sir?
That is understood.
Mr. Baloyi, what is your excuse?
As a court case, my lord, the document was disclosed to my colleagues in line with what the court said yesterday, that it's only meant for the eyes of the court as well as the defense counsel.
No, but they say the accused were reading it.
Yes, well,
they got it obviously from the...
yes.
Actually, I'm shocked, that senior counsels like this can actually behave in this matter. I'm just shocked. I explicitly said it's only for the court officials. Now you're telling me the accused are having... This gentleman is right when he says he doesn't know whether tomorrow some of the witnesses will be dead or not. Because this is, unfortunately, is a type of case we're dealing with, unfortunately, where people are said to be shot, etc., etc., etc.
But I've just asked my learned friend to give back the copies to minimize the impact that there might be. And the copies will then be...
Mr. Mngomezulu, what's your view now?
My lord, I would like to exonerate myself from...
Hello?
I would like to exonerate myself. I've never consulted with the clients or with the accused.
Where did your clients get the document? Already?
No.
Which client and which accused?
Muzi le ka mogala one ba go bakanetse mara ba ile beletse ka mo. Ba ba sere pampiri jo ka mo.
Muzi and all of them they were...
Who is Muzi? Accused number who?
Muzi
is number 1.
Accused number 1, man.
He was reading that document.
He
took it and he went towards them and they were all together reading the document.
Yeah. And Mr. Nisi?
My lord, I feel a bit uncomfortable when the court says
Yeah.
And I'm saying this with utter respect for the court. When the court says the court is shocked that senior counsel such as us here
If it's true,
we do
Yeah,
such
you're
a
right.
despicable
Maybe a
thing.
mistake.
It is
If-
indeed despicable.
if it is true,
Yes. But what worries me is I don't think a statement that has been uttered by the court in the circumstances where it has not been determined exactly what the circumstances were through which this accused person were able to see that document. It's a bit appropriate, man, because now it seems as if all of us they just decided to stand up and give these documents to
no, fine. You can tell me.
Coming
Is your
to the
client,
accused.
did your client see that document? Because that's,
I did not consult with my client this morning.
did he
man, but
see? You don't know if he saw the document.
I don't know whether
Okay,
he saw the
fine.
document
Mr.
or what.
Nimalo?
My lord, I'm not so sure. Why is this witness worried about the statement that he has made? Because in his own statement that he made on the 25th of October 2023, he refers to one of the cases where
Now that's obfuscation. Do you know that word? Obfuscation. Hello? Do you know obfuscation?
I'll have to go to the dictionary.
OBFUSFUCATION. Obfuscation. That's what you're doing. We're dealing with the present situation. You're telling me about an affidavit of a person who you say.
No,
We're talking about a court order which said he must bring that information and it mustn't be made available to any other persons except myself maybe and
Then,
the council. Now you're talking about,
yes. Then in that information that he provided, in his statement, I'm saying in his statement, he refers to one of the cases that are detailed in that document that he provided to my colleague this morning. One of the cases are referred there in his own statement that he made. So I'm failing to understand, my lord, how I have
you
not-
don't even know what cases is referring to in the document which he wrote. Maybe the very case you are quoting is not of any moment according to him. Are you with me? It's like the Nongoma case. You can mention it because we have dealt with it.
My lord, the court is not understanding what I'm
I
saying.
understand fully, sir. So did your client have access to that document, sir?
I did.
This court. Hello?
I did consult with my client.
And you
based
showed him
on-
the document.
I consulted him based on one case that is mentioned in that
Sir,
document.
did your client consult, have access to the document which I said the sergeant should write for my own perusal?
Yes, he did, because I had to consult with my client based on the case that the witness has documented in his own affidavit. The consultation was based on that.
Ms. Mshololo, what's your view?
My lord, may I ask beg leave to consult with my client because I personally have not read that information.
You are not aware of that information.
Of that information, but may I just clarify from my client if he,
Yeah.
thank you. Thank you, my lord, for the indulgence. My lord, I have not read or consulted with my client regarding the document that was given to us by the state. And my client informs me that when they were grouped together with accused number 2, 4, and 5, they were reading this document, my lord. Or maybe if I can just show it to
It's
my
not the
lord.
one that is prepared by.
It's not the one, my lord, yes. And they are indicating the page that they were looking for. Where
Whose
it is.
document is that?
It's an indictment, my lord.
Oh, they are reading the charge sheet,
They were reading the charges. They
which
were
they've been
discussing-
reading in the past 3-5 years.
No, my lord, but that's what
No,
was
I
happening.
hear you.
Yes, yes. This
Where's
is
that confidential document, Mr.?
The document
Because
they
now
were
we're
reading?
getting
yes.
the fact that now.
Sorry, my lord, can I just get further instructions, my lord? I see the hand is up from my client.
Yeah.
Thank you. My lord, just to add, my lord, as to what were they discussing in this indictment, my lord. He says they were discussing about witness number 104 who is being referred.
Now they can discuss their indictment, no problem.
Yes,
no problem.
I just wanted to be clear
fine, I appreciate
as to
that.
what is it that they were discussing in
This
this
inquiry is about whether or not this order which I made has been exposed.
Yes, my lord. Those are my submissions.
Mr. Aloy, where's that document which you given by?
I'm just trying to get all the copies from my colleagues.
My lord, before the copies are being taken back, with due respect, my lord.
I want the copies which the gentleman, the witness, made to be put in the same envelope which was supposed to be for my eyes first. You know, during apartheid, I must say this, we had apartheid judges in these treason trial cases where a judge would make an order that an investigating officer should do what I did. And then he would say that the order is just for the court. And even the counsels who were in court would never ever be aware of that order, because the judge then had a discretion whether to disclose that information or not. And invariably he never disclosed that information. Now we think we've got a democracy here which is functioning. And then court officials will know what to respect when a judge says that order is made to divulge certain information which is not supposed to be made available to the public. Just check whether all these documents are the ones which you... Do you have a copy of the original document?
No, ke di file ntate Baloyi, ke mo file
How many?
file ntate Baloyi original document.
I gave Mr. Baloyi the original document
And I did that copy.
and he made copies for himself.
So there was one document.
The document here did.
So na ke na yona, ke nka ntirele yona.
Okay.
I do not have it. I said he should do it for me.
Is it Gininda who will know? Just listen to me. Is it Brigadier Gininda who will know under which section of the Intelligence Secrets Act these documents are categorized?
Le go tlo kgonagala gore le tsebe gore ditokomane tše di mo sectioning e feng.
Ke tseba ka di ndao le mo secret service le crime intelligence.
I am informed that they are on the Secret Service and Crime Intelligence.
Okay, can you bring those documents?
Sure.
In the nature of things, these documents are not going to form part of these proceedings because that evidence has now been contaminated. And this court has got a discretion to decide whether to make these documents available as I originally intended. Because from what this witness is telling me, if I do that, some people's lives will be jeopardized. It's not saying that. He talks about people being killed. He talks about guns swirling around. He talks about kidnapping. He talks about whether his witnesses will be safe and alive tomorrow. So this court makes a ruling that this information must be expunged from the record of these proceedings on the basis of the fact that it may jeopardize other persons' lives, which are more important than the life of this judge. Okay, Ms. Msholo, let's go on.
My Lord, can I ask that we take the long adjournment and now resume after lunch?
Okay. What's the time there?
Council now going to proceed.
Yeah, I'm going to proceed with the cross-examination.
Along the lines that she was doing.
Yes. But the only order I made is that this confidential information
Khoro e re ditokomane tsela tse le batlileng tsona ga di jwale khoro e tlo di swara ka lebaka la mabaka a besitseng le fane ka ona e be go bolelwa ka maphelo a batho.
Bonke labaphefumuleli ukuthi usetshenziswe walethe la enkantolo kuyazochitha enkantolo ayasasetshenziswa kulolu daba.
just for my own edification, where are the dockets?
Di docket di kae?
Docket ya Fosloras. Since ba isha decision I so
Case number?
Di case number e feng?
534.
Aksa go pola case number.
What's the charge? What's the charge?
Cha molato wa bona be
The person dealing in drugs.
dealing in drugs, my lord.
Yeah, it's 534 if I recall. 534
Something, yeah.
of 6.
Khoro e re e ka re ke 5346.
And the other one?
Yengwe.
Ekia Nongoma 160 of 10
And this one it's for Nongoma 160
of 10 2018.
of 10
160
2018.
of 10, 2018.
Yes.
Where is the docket?
E ka yona.
Normally ishila ke ikreya my lord because Colonel Ginda we will some rotla tla lebella.
I
Okay.
did not get it where I left it, as Colonel Ginda said he will come and look for it.
And the other one?
Yengwe guy.
No chona chepe jibele.
Those are the two that the court needed.
Okay, 2 o'clock.
My Lord, can I make one submission, my Lord, with due respect? I know the court has ruled, but it is my request that that information that has been taken back from us, it must not also be kept with the court,
Why not?
because that information is coming from the witness.
Did you hear the ruling I made?
Yes, my Lord.
What was the ruling?
That we are not entitled to it. The order was that the witness must bring this information for the court purposes.
Right.
Yes, my Lord. My request, my Lord, is that the information cannot come from the witness direct to the court without us having been given an opportunity to look at the information that is submitted before this honorable.
I thought you had seen it, all of you. You just gave a copy. Didn't you give a copy?
I have not seen it, my Lord.
Okay, take
I
it.
have not seen it, my Lord. Thank you.
This information will form part of the proceedings of this. Just give it.
As the court
So that
visits,
if this case goes somewhere else, the
As-
judges in the SCA
SCA.
and the judges in the Constitutional Court
Thank
will have
you.
access to this.
as the court visits.
I'm not so naive as to take the information which has been led to this court and go and keep it in my sitting room.
Thank you, madam.
Judge ba khopela gore ditokomane tsela di ska ya thuto khoro le ma wa tso.
I, the court. So, Mr. Balui, you made how many copies?
Enough copies to
Yeah, but in other words, how many copies did you get? Is it 1 copy or 2 or 3?
we got all the copies back.
No, you're not listening. This witness, how many copies, let's say, how many pages of the order I said he must give us the information on? How many did he make?
2.
When said the copy second, how many copies did you make?
There was only one.
1 copy.
One copy, madam. And
Okay.
made just enough for council.
Right. So every counsel has got that order, eh? And every client has read it. Mr. Mngomezulu, the client read it also.
Not.
This witness says he read it. Said, are you saying you saw even number one reading it? And number two?
He was sitting together with him, but I'm not sure if
And
he
number
was.
three? All five of
Number
them.
one went to the group, my lord, and they looked at it together.
All five of them.
Correct.
Can you give all five of them copies? Copies so that I just read what the law requires. Mr. Baloyi, can you give each and every accused that order which was supposed to be made for this court, which has now been publicized?
We will make them copies.
Now give them now. I've got to see them getting it.
Well, we only made enough counsel. We'll have to make extra copies.
Councillors have got all copies. Mr. Mngomezulu, do you have a copy of that order?
This is the copy. My
Do you have a
colleague
copy?
is- No, I'm about to receive a copy now.
Mr. Mnisi, do you have a copy?
We thought we needed to take them back, but now they are being returned back.
No, you have to get copies, all of you.
As it is of course.
Mr. Numalo and Ms. Mishororo, you all have copies.
Yes, I've just received it, Madam. Thank you.
Yes, my lord, I've also just received it. Thank you.
Yeah, it originally ruled that that order must be expunged. But after having consulted authorities, in terms of our law, there's what we call a posterior ruling, a statement. And Black's Law Dictionary, the 10th edition, defines it as such. A formal statement endorsed on the trial record. That's what I'm doing. I'm endorsing this order, which I thought it's going to be confidential, on the trial record. Giving an accurate account of the proceedings at the trial, which I hope I've done. A record of what occurred at Nisi Prius after the issue had been joined. The issue was joined on the basis that when this witness, Sergeant Mokhanene,
Yes, my lord.
was being cross-examined, he repeatedly said he's unable to divulge the information regarding the investigations of the cases which you say accused number 1 or 2 or the others they're involved in, because you would be revealing confidential information. Am I quoting you correctly?
Ke nnete gore kgoro e re lena le go na le dilo tse e leng gore ga le kgone go di bolela ka lebaka la gore go na le ba bangwe ba ba latofatswa ba e leng gore ba gona go melato e nngwe gape le tlabe le ntšha dilo tse e leng gore ke diphiri ka sewe sebaka. It is correctly quoted, my lord.
Yeah, because this court hopes to be fair. There was a dispute as to whether this witness is actually, his testimony is actually the truth or not. And at that stage, this court is not involved in joining whether this witness is being truthful or not, because he's at the moment giving evidence. This court decided, in the interest of justice, that if it is actually correct that these cold cases he alludes to, including the Nongoma case regarding the murder, the court should make a request in the form of an order that this witness should itemize and categorize those cases in which he says they are cold and they are at the moment not yet finalized. Because it was put to him that, for instance, that Nongoma case was finalized, and he said, no, it's not finalized. And by that exigency, this court expected and hoped that this court will get the information which it will share with the accused counsels, that in fact, indeed, such cases are still being investigated. Is that not your evidence, sir?
Ga se botlhatsi ba lena se kgoro e fetsa go se bolela ka dijwane gore melato eo e santse e nyakišiša.
Indeed.
It is correct, my lord.
Consequently, that's why I made that order. And I was of the view that that order is made for the information of this court. And in terms of this posterior principle in our law, I was going to call all the counsels into my chambers and show them the confidential information which was divulged after being extracted by this witness from the various dockets. Because I believe that counsels are officers of this court before they are defenders of their accused. That's a sacrosanct principle of our law. You are officers of this court before you are defenders of the accused, because when you are admitted as counsels of this court, you take an oath to uphold the law practices of this court. So one would have expected that even if counsel informs their clients about the fact that in fact it is correct that there is proof that some of the cases which the gentleman is giving evidence on, saying they are code, but they have been resuscitated, in fact it is correct that those cases are being attended to. And I believe protocol dictates that not everything which this court divulges by intruding into the Official Secrets Act. And if counsels understand that exigence, you don't have to tell your client about the fact that they say one of the murderers there is Mokhatle, because you are enjoined to the privity of the information which has been divulged in this court, because this court has made an order that even if it is in terms of the Official Secrets Act that this witness was saying he can't divulge that information, but this court, using its inherent jurisdiction and Section 173 of the Constitution, as Mr. Minister likes saying, you can make use of that information under certain conditions. Okay. So consequently, if anybody wants to use that information, which has been so irregularly been divulged, you are at liberty to do so. And this principle starts from the 15th century, so that the man say, "I did judge lay is a long term." With the verdict of the jury in the 15th and 16th centuries, the proceedings at Nice was closed, and the case was sent back to the court at Westminster, from which it was issued for judgment after a statement of the holding of the trial and the verdict that had been added to the record, as I'm doing. This statement, from the fact that it has begun with the Latin word postea, or afterwards, was known as the postea and was in fact drafted by the party in whose favor the verdict had gone. Whence the phrase postea to the plaintiff or the defendant, which is found in the old reports. You can see in this regard Geoffrey Ratcliffe and Geoffrey Cross, Legal Systems, England. It's a 6th edition textbook written by Bentley and Hand. It's the 6th edition if you want to read about this any further, 1977. Okay. Yes, okay, Ms. Msholole, you can go ahead and cross-examine.
That's the court business. My Lord, before I resume with my cross-examination, can I just ask one thing on clarity, my Lord? So it means that on this document, I can read it but not consult, share it with...
No, it has already been shared. You can read it and share it with your clients. That's why I insisted that each of your clients should be given that document, so that it mustn't be said that this information which this court has withheld.
That's the court. Thank you, my Lord.
Yeah, well.
Sergeant Mkhane, let's just go back where we paused yesterday. I'll try not to repeat myself, but we'll just wrap up somewhere there and there where I need clarity on those issues.
But tswela pele mo ele gore le shile gona maobane ge e le gore bona ga ba nyake le gore ba boele go tse dingwe tša dilo e fela ge e le gore bona ba tlhoka gore ba kwešiše dilo tse di rileng ba tlo le boša ka tsone le ya kwešiše.
Ke a kwešiša.
That is understood.
Subela emuva kuloko esifunde olesikhuluma ngayo kuzona ngesiqeda konke kodwa khona izinto ezifanele zicacise.
For the sake of progress, you remember we were talking about the interview that took place at the boardroom.
Gore re tswela pele jwatse le a gopola gore be re bolela ka poledišano ye e diragetseng ka boardroom.
Ngiyakhumbula
Yes.
esikhuluma ngale kwakhulunywa e-boardroom athi yebo.
I'll just ask one question in that regard and then move on in that aspect.
Ba tla botšiša potšo e tere ka yona tabewe ye be le gore bona ba tswelela pele.
Shuthi zobuza umbuzo owodwa nje kuloko bese siqhubeka phambili.
Feleditse.
I am listening.
The interview that took place between yourself and other members and the suspect was not recorded.
Interview yela ye leng gore lena le be le gona le ba bangwe ba be leng gore le berekisana le bona be se e recordiwe ga se gatišiwe felo tsoko.
Ke nnete.
Correct?
Manje lokhu enanikhuluma wena nalaba abanye azange kuqoshwe phansi okuthamba.
Okay. If I can just take you back, also I just need confirmation. When you firstly approach accused number 2, when you arrested him, you explained to him the allegations in respect of the Nongoma case. Am I correct?
Ge le ya go molatofatšwa wa bobedi la mathomo le ile lena la mmotša ka molato la wa Nongoma.
Ke nnete.
Correct?
Manje kuqala kumsolo nafike namtshela ukuthi usolwa ngani mayelana neNgoma athi yebo.
Okay. And then when you were charging him,
Ge be le mo rwesha melato
then which allegations did you refer to him?
le mmoditše ka gore lena le mo rwesha melato ka eng.
Manje baseke nizomtshela isicala belithe ukuthi mthose icala ngaliphi.
Ele ka tlhalosha le bolela ka isale ka June.
Can you please explain further? Are you referring to the month of June?
Yeah, the month of June. You have arrested him from his house. And then you explain the allegations in respect of Nongoma case. Correct?
Ke
Ke re le mo
nnete.
swere ntlong ya gagwe. It is correct?
Yes. And then you took him to the station.
La Misha Spodise.
Nnete.
That is correct?
Namthatha namisa esiphoyiseni athi yebo.
Wherein he was charged and detained.
Ke mo ba ileng ba mo rwesha melato la mo tshwara.
Ke nnete.
That is correct.
Atshelwa amacala akhe waseyavalelwa athi yebo.
Yes, at that time, when you charged and detained him, which allegations did you explain to him? Was it in respect of Nongoma case or in respect of this case, Foster's case 636?
Ge ne le mo tswallelela le be le mmoditše ka melato e mefeng le mmoditše ka wola wa Nongoma goba le be le mmotša ka wo wa Phosphorus.
Manje masenze umvalela amtshele ngaliphi icala ela bona Ngoma nona nimtshele ukuthi unecala lelaseflosloras.
Re monitse ka molato wa Nongoma.
We informed him about the Nongoma case.
Samtshela ngecala wala Ngoma.
Okay. So, then on the following day, when you booked him out, you then interrogated him on the Foster's case 636 and not Nongoma case.
Letšatši le latelang ge be le montšha le lo mmotšiša dipotšišo le ile la mo thoma dipotšišo ka molato wola wa Nongoma e seng wa Phosphorus.
Re thomile pele ka Nongoma then ra latela ka Phosphorus.
We firstly interrogated him on the Nongoma case and then followed up with the Phosphorus case.
Ngilandelayo kumasikhipha na nakhuluma ngecala lakwaNongoma noma elaseflosloras. Athi asaqala lelaseflosloras sasiqhubeke nalawa Nongoma.
Okay. And then in respect of this Foster's case 636, the accused number 2 denied any involvement in this case. Am I correct?
Molatofatšwa wa bobedi ka molato wa Phosphorus 636 yena o ile a ganela gore ga se nke ya ka karolo ya molato o. Ke nnete?
Ke nnete.
It is correct.
Waphika umsola ngithi kule icala laseflosloras ukuthi uyalazi wathi akanazo athi yebo kunjani.
And then, in respect of the Nongoma case, if I remember very well your response yesterday, he was never taken to court for his first appearance at all.
Ka molato wa Nongoma ge ba gopola botlhatsi ba lena ba maobane lena le rile ga se nke a išiwa kgorong
Hello, Pichagabuji. We are Mishi Horong, who Merifita Horong, Chuchisarno, Carvel, Nongomai, Asserts, Shiniagare. And then Labari Mishagaya Fosloras.
If you would recall properly, we took him to court and the prosecutor said, this Nongoma case, it's not under their jurisdiction. Then that's when we had taken him for the Fosloras case.
Yeah.
Which is sometimes what I was
Yes, but in essence, he was never taken to Nongoma court for his first appearance or for his appearance under that case. After the prosecutor has said that he does not have jurisdiction over Nongoma case.
Kamraga gore mochuchisi a re yena yela ya Nongoma ga e ka fase ga jurisdiction ya gagwe ke mo e leng gore yena a senke a tswelele pele ga kgorotsheko ye e rileng ka molatola wa Nongoma. It is correct.
Okay. So it means, Sergeant Mohane, on the 19th, I suppose we are on the same page that you saw the prosecutor on the 19th of June.
Le a dumela gore le bone mochuchisi ka di 19 tsa June. That is correct.
So it means on the 19th of June, when the accused was not taken for his first appearance, the 48-hour rule expired in respect of Nongoma case, since he was never taken to Nongoma court for his first appearance in that case.
Gora gore jwalo ka ga lena le bone mochuchisi ka di 19 ke ge ile gore ge molatofatšwa ba sare yena a tsena ka kgorotshekelo ke mo e leng gore di hour tsela tše masomenne seswai be se di expireile ka molatong ola wa Nongoma.
Nje jomba yena amisanga yakato mala netsalana ufuthikela mahora awu amashuma mane shaka dombi usutha seqile mala netsalana Nongoma.
No, we saw expire.
No, the 48 hours had not yet expired.
Okay. It's fine, I'll leave it for argument. Let's continue. You then, on the same day, on the 19th, when accused was not taken to Nongoma court for his appearance, in Fosloras, his case was not enrolled, and he was supposed to be released. Am I correct?
Jwalo ka ga lena le re ka di 19 tshekong yela ya Nongoma ga se a ye go dula go yona go ra gore yela ya Fosloras o be swanetse molatola wa gagwe o tshollwe go jwalo. That is correct.
Goba ke azali gene itsala lilana no ushuthi ke itsala se Fosloras la ngafanele lichithwe ngaphandle ebese yakhululwa umsolo nje njalo.
And he was not released. Am I correct? According to the exhibits that we have read into this court.
Go ya ka botlhatsi bo lena le bo badileng mo khotla tshekelo ma lena ga senke le moloko le molatofatso.
Kodwa zange nimkhulule njengokungala maphepha phambi kwethu.
And a further detention after there was an endorsement that the accused must be released was unlawful because you did not have any warrant of arrest to arrest the accused on any other further or subsequent cases that you were investigating.
Se se bolelang gore lena le tswele pele le moswere besche go le ka ntle ga molao ka lebaka la gore le be le sena tokomane ye be le dumella gore lena le be le ka moswara go ba le ka motswallela nako e nngwe e fetang eo. It was not unlawful, however, we did not have a J50.
Thank you for that.
Avalele umsolo ushubo ungasekho emthethweni ngoba nani nazo icharges ukuthi ningamvalela ngalamacathi yebo kodwa ke sesingaya J50.
Yes, at that time when you did not have a J50 authorizing you to detain accused number 2 further after his matter had not been enrolled in forced lawyers, you took him further for further investigation. Am I correct?
Ora gore jwalo ka ga lebele sna yona J50 yela lena molatofatswa le la motšia le ge ile gore lebele sna tukelo ya gore lena le ka moswarella lena la motšia le lo motšiša dipotšišo le lo nyakišiša. It is correct.
Athi njengoba nani ngenayo J50 kodwa na vele namthatha umsolo naqhubeka ukwenza uphe nathi yena.
Okay. And am I correct to say, after forced lawyers court, when he was detained around 1339, you recall me if I'm quoting the time wrong, it was 1339. From 1339 up to the time when he was detained at Pukeng police station, you had no warrant of arrest in your possession to keep the accused in your possession.
Ora gore lena go tlogelle nako yela ba re le tla ba phosholla ge ile gore nako ga se ba ebe ga botse nako yela ya 1339 go fihlella le be le mo tswallela ka kwa ka police station ya Phuket ra gore lena le be le sena tukelo tsa gore le be le ka moswara.
La película se es que se te dice que no digo que es que no pasa nada. Es que nada de que
Okay. If I also recall your examination in chief, the reason for you to take accused number 2 to his house is because you wanted to check the hoodie that he was wearing. When the incident in the forced lawyers case 636 took place.
Am I correct? Forced lawyers case 636 I do not understand. Can you please rephrase so that I will be able to understand correctly?
Okay, thank you. I'll repeat. And if I'm correct from what you said, your evidence before this court, you said the main reason you did not release the accused from forced lawyers court and proceeded to his house because it was because you wanted to go and search for the hoodie which was worn by the suspect on the date when the incident took place under case forced lawyers 636, which we are dealing with in this matter.
Le rile le baka le dirileng gore lena le ska tala molokolla ke ka lebaka la gore lena le be le nyaka go misha ntlong mo be a dula gona gore le ilo lebella hudi go ba ke fa yela ye leng gore ba ere ka tšatši le be go diragala molato wa forced lawyers case 636 ye re bolelang ka yona ya mo
bisho sizathu sokuthi ngingamekhulule emva kwase forced lawyers ukuthi nanifuna ukuya endlini yakhe ukuthi niyohlola ukuthi ngayithola yini le hoodie yayigqokwe umsola kuleli cala bese forced lawyers 636 unjalo.
Yes, as we were still gathering evidence for the case 636, he is correct.
Okay. Is it also your evidence that in 6 years' time, from 2014, 15, 16, 17, 18, 19, 20, 6 years later, you proceeded to accuse number 2's house with an intention to search and seize when you did not have a warrant, a search warrant in your possession in respect of the case or in respect of the information that you wanted to search and seize?
Le bentse le nyaka go ilo tswella pele lilo lebella lilo tlhola kwa gagabo go ba mo be a dula gona le ge ile gore lena le be le sena dipampiri tše e leng gore di be le dumella gore le kae le ilo sesha
Mhlawumbe kwaminyaka eyisithupha nasuka la emzini kaMsolo sibili ukuthi niyohlola noma niyowenza uphenyo noma ukuyosesha ningenayo iwarrant mayelana nalezi nithi niyozithola lapha kuyani.
Re ka gopola botse molato a so thome ke rena mathomo for 2014.
If you would remember properly, this matter, we are not the first investigators since 2014.
Mangakhumbula kahle thina ukuqala ukuthi siphendule lucala kusukela ngo-2014.
Go fitile matsogo a mantši kudu go fitlhela rena ba re fa ona.
There are many investigating officers that has worked on this case until it was brought to our attention.
Baningi abaphenge leli cala lapho izolethwa kwe-ET.
Rena re hweditše molato ka December 2019.
We got this matter in December 2019.
Thina sathola leli cala ngo-December 2019.
Okay. Thank you for that explanation. But I don't have a problem with how many members who have investigated this case. That's not my question. That's not where I'm going to. Whether you were the 15th or the 30th member to investigate this case. But on the 19th of June, when you went to search in accused number 2's house, you were not in possession. You did not have a search warrant authorizing you to go and search the item that was worn by accused 6 years back. That's my question.
Apo ba leboga le gore le na le ba botse gore ga se lena ba mathomo ba go bereka go molato eupia selo se ba se bolelang ba re ka di 19 kgweding ela ya botshela le na le be le sena ditokomane tše leng gore di be di le dumella gore le ka sepela le ilo nyakishisha ka molantlong ntho e leng gore molatofatša o be a ya pere mengwaga ye tshela ye fitileng
Kuzothi kusho ngomhlaka 19 kuJune ayiphethe warranty ukuthi niyo session lapha endlela yamsola ufuna lezi zinto zazigqoke sola ile minyaka esithuphe eyadlula.
Go na le molaotsoko ka mogare ga Criminal Procedure Act o re dumelelago go swara ebile le go searcha re sena warrant ebile gore a ke sa gopola ke tla ile go lebelela gorena gore molaotsoko.
There is a certain law in the Criminal Procedure Act, even though I would not recall which section refers to that. However, I will go and search for it, which allows us to arrest and search a place even without a warrant of arrest.
Yeah, no,
or a search warrant.
Ngena ukuthi singasho session nanoma singenayo iwarranty sizofuna lo mthetho kuphela. Ikhona lo mthetho.
No, thank you for that. Don't worry about that law. We'll argue about it before this court. The only confirmation that I want to get from you is whether did you have a search warrant or not.
Ba re le ska tshwenyega ka molato o bona ba tla o lebella gape ba tla ba boleishana ka ona bona mogoro. We did not have a search warrant.
That's all I wanted.
Singenayo search warrant.
That's all I wanted. And then you entered accused number 2's house and you searched and recovered the ammunition. Bullets, if I'm not mistaken. Am I correct?
Le ile la tsena ntlong ya molatofatšwa wa bobedi la tlhola gana ka molala khumana dipile dikolo.
Ngangena lapha dinamsolo esibili nasesha ngina nithole inhlamvu zesibhamu.
Ke nnete?
It is correct.
That is correct. Kunjalo.
And also you did not have the search warrant regarding any bullet or any firearm that you were looking for.
Le bentse le sena yona tokomane ela ya gore le search re be le ile go fumana tsona dikolo tšeo.
Ngenayo imvume yokuthi niyofuna inhlamvu zesibhamu.
Ke nnete?
It is correct, so.
Okay.
Kunjalo.
Thank you. Let's go back a little bit on the occurrence book. Since we have testified, maybe you can refer if you want, but I will remind you.
Ba re tlo boela morago go occurrence book ge ile gore le na le nyaka le ka ya go yona fela ba tla le go potsa.
Accused number 2 denied any involvement in respect of Foster's case 636 when you interviewed him in the boardroom on the 17th of June 2020.
Molatofatšwa wa bobedi yena o ile a gana gore e be ile karolo ya molato wa Foster's case 636 ka di 17 ja June 2020.
So the wesibili waphi ukuthi yena uthingayo leli cala lika 636 laseFoster ngicase ukuthi ni lapha eboardroom manje Muzi Sibiya.
Ke nnete?
It is correct.
That was the first and genuine response given by accused number 2 when he was asked about this matter of phosphorus case 636?
e be le karabo ya gage e ya mathomo ya nnete ge be le mmotšiša ka molato wa phosphorus 636.
Impendulo yakhe yokuqala yophendulo manje imbuzo ngale cala 636.
ge le re ya nnete le ra yang ka gore e tshwanetse go be le phetolo ya mathomo re ya nnete a kušo le be re ya nnete le ra yang.
What do you mean when you are saying the first genuine response from him? Because we were expecting the first answer
Okay.
from him.
Let's move on. Let's move on. On the 18th of June, he was then booked out for the whole day on the 18th of June. You
Around
remember?
Zwelling Pele.
At 8:15, as per serial number 520.
Le a gopola gore ka di 18 tša June.
That's the
Yeah.
exhibit entry that you have read into this court.
O ile a tšewa ka 8:15.
He was
go ya-
booked out at 8:15 and only detained at 2:30 in the morning.
le mo tšere ka 8:15 yena a bušwa ka 2:30 e leng 2:30 ya matsha go ya ka mokgwa
ke na yona mara ke tla ke a gopola.
Yeah.
I do not have it, however I do remember that.
Mhla 18 kuJune wakhishwa ngo-8:15 ngale umbhalo lo bhalo utho 520 wazofisa ngo-2 ekuseni.
Yes.
Wathi yebo njalo kodwa anginawo ke lo mbhalo wona.
And then on the same day, on the 19th of June, at 2:35, the suspect was charged. You remember?
Ka lona tšatši leuwe
That
la
one.
di 19 tša June ka 2:35 ke mo e leng gore molatofatšwa o ile a rwešwa melato le ya gopola.
So then
Ya
I'm
gopola?
trying to
Yes, I do recall.
Ngo-2:35 umsola ilapho katsho siqalathi yebo.
And early in the hours of the same day, 19 June, at 4:50, the suspect is booked out to Phosphorus Court.
Le a gopola gore ka masa ka tšona di 19 tša June ka 4:15 ya masa ke mo e leng gore molatofatšwa wa tšewa o išiwa kgorotshekelo ya phosphorus.
Ngo-4:15 ngalelo langa umsolo wakhishwa enkundleni yamacala yasephosphorus.
Ke nnete.
It is correct.
Yebo kunjalo.
And according to your examination in chief, when you were on your way, after you had booked out accused number 2, you were called by Colonel Gininda, who told you that accused number 2 wanted to make a statement. Am I correct?
Le a gopola gore lena e rile ge le le mo tseleng ge e le gore le ile la khumana mogala go tswa go Colonel Gininda a le botša gore le molatofatšwa o be a rile o nyaka go bolela ntho e rileng.
Ngisakhumbula ukuthi-ke nathi kusendleleni nathola ukuthi ngavela ku-Colonel Gininda ethi-ke umsola ufuna ukuyobhalisa-ke i-statement esithize.
That's not the evidence I listened to.
Oh, sorry.
They got a message from Gininda to say, no longer go to
Court.
the court.
Yes.
Go to Morocco because I have now located a person who can take a confession. After Gininda had told them the previous day, told accused number 2, if the evidence of the sergeant is correct, that you don't have to make a confession or a statement before me, I'll find somebody to take your confession. Okay, that's the evidence.
Yes, my lord. Should I
Not
read
that
other-
Gininda told them on the way to say the suspect wants to make a confession. No,
Okay.
we had
But,
already said that the previous day.
my lord, but the call was made in the morning when they were on their way to Phosphorus Court
To say what?
to say that the accused must be taken to make a statement.
Yes.
Yes.
Not that he wants to make a statement. Because the arrangements were already made by Gininda, in other words.
Thank you, my lord.
Yes.
Can I just proceed, my lord?
Yes,
with
do proceed.
the line of my questioning, because I'm now getting distracted.
You're not, Ms. Msololo. I'm quoting the correct record, what it says. You can ask Mr. Mngomezulu, am I confusing anything?
No, my lord, this is
Hello?
the correct
Ms. Mshololo was not there. I'm quoting the correct evidence. Now I'm being told I'm distracting.
Thank you, my lord.
Please.
My lord, can I proceed? My question is, why now, when the accused has been booked out from 8 o'clock up to 2:30, when he was booked back, now that he has changed his mind?
Ba re putso ya bona ba nyaka go tseba gore gobaneng jwatse ge mo
It's a good please, my lord. I don't know why counsel says the accused has changed his mind. The court is just now put to counsel what the correct version is, that the incident started already the previous day on the 18th when they were in Carltonville, where he intimated that he would want to make a statement, and Brigadier Gininda then said to make arrangements. And on the 19th, he contacted the witness to say he has made arrangements. There's no change of mind.
Can I rephrase that question, my lord? Is it correct that the accused only indicated that he wanted to make the statement during the time when he was booked out for long hours, from 8:15 up to 2:30 in the morning, when he indicated that he wanted to make the statement?
a fa ke nnete gore molatofatšwa yena o rile o nyaka go dira statement nako ela ge ne ba mo tšere nako e telele go tlogeleleng ka 8:15 go fitlhelela ka 2:30 ke mo e leng gore o ile a re o nyaka go dira statement.
Once again, I don't know whether the part that says when he was booked out for long hours is correct or not, because the witness said it was around 4:30. So it was from 8:15 to 4:30 when he signaled his intention, when he made certain admissions, Lord, and arrangements were then made. I think the addition of long hours will not be correct.
Thank you, my lord. I'll leave it for argument, my lord. Can I just move on? Because the hours are indicated from the OB entries, my lord. Let's move on, Sergeant Mohane.
Mara taba ela ya di-iri tše di telele ba tla e lesa ba tla e sheka bona ka bona ga ne jwale re tswela pele.
Is it also your evidence that when you were with accused number 2 in hospital or outside hospital, he was also asked about the involvement in the case of Phosphorus case 636?
Ke botlhatse ba lena na gore molatofatšwa e rile ge be re na le yena ka ntle ga sepetlele.
On the 18th of June, when you booked him out and went to hospital or his place of employment?
Ka di 18 tša June ge be le mo putlile out le ile sepetlele goba mo be a šoma gona. It is not the hospital, it is where he was working.
Where he was working. Thank you. And where he was working in hospital, you also had interview with the suspects.
Mo be a bereka gona le ile la kgona go boledišana gape le yena le ba le interview.
Rapele or re šetše re feditše ka go tšeka go lebela gore o ba se go mmereko.
Are you saying before or after we had checked that was he at work or not?
No, at that time. At that time, I don't know according to your evidence. It can be before, it can be after, I don't know, but you were at his work employment at that time when you interviewed him.
Ba re ga ba tsebe gore be le ka pele go ba besitše le ka morago fela ge be le mo yena mona mo be a šoma gona.
E ke gopelang gore ke rile Brigadier Gininda o re joinile le Sergeant Mogola.
What I remember is that I said Brigadier Gininda joined us with Sergeant Mogola.
uBrigadier Gininda kweza wazohlangana nathi no Sergeant Mkhula.
Yes, and then what happened?
Be re ba emetse mo gate-ing ka ntle ga mine.
And we were waiting for them at the gate outside the mine.
So sibalinde esangweni ngaphandle kwemayini.
Gomme re Brigadier Ginda fihla le Sergeant Mkhula ka mo introduce go Brigadier Ginda wa ke Senzo Meyiwa.
And when Brigadier Gininda came with Sergeant Mokhola, I introduced him to the Brigadier that this was
Senzo Meyiwa.
Senzo Ntanzi.
Wathi kumefika lo Brigadier no Sergeant Mkhula ngasele ngimethula ngithi uyena ke lona uSenzo Ntanzi ngithula ku Brigadier Gininda.
Wela mo tsara ba re tlile go verify gore ka nnete go lo mshomong na ka re ke mmodi tsa Brigadier Ginda.
And Brigadier said, we are here to make sure whether were you indeed at work, as I had explained to the Brigadier.
Athi ke hayi ke ngiyathimachaza ukuthi ayisidana nje uzothola isiqiniseko sokuthi ke ngempela ukhona yini emsebenzi njengoba kuchaza kokhulunywa uBrigadier.
Ke polishano re bileng le yona pele re tsena ka gare ga mine.
That is the conversation that we had before we went into the mine.
Yena ngizokhosa abanayo bese ngangena emayini.
Okay, in other words, at no stage wherein the accused was asked about his involvement in this case at that time.
Kana go ewe ga gona mo eleng go fatswa o ile a botsishiwa ka kamano ya gagwe go molato.
Futhi lapho ke akukho la umsola abuzwa khona ukuthi uthengeleka kanjani kuleli cala.
No, Brigadier Ginda ya mmutsisha after amu muritse ditokelo tsa.
Brigadier asked him after he explained his rights to him.
uBrigadier wamtshela emva ukuthi wambuza emva ukuthi amchazeleke amalungelo akhe.
And were you present?
Lebelele gona.
E be ke le gona.
Yes, I was.
Wakhona thi yebo.
Okay. Did accused respond?
Molato fatswa o ile a araba.
Sola waphendula.
A wela homola.
He remained silent.
Vele wathula.
And then on the 19th, early in the morning, when you had received a call that an accused person must be taken to Lieutenant Colonel Rapado, did you take him to any police station
Hoseng
according to your evidence?
re le na le fumana mogala wa gore molato fatswa o swanetse a ishiwe go Lieutenant Rapado le ile la misha.
Ekuseni yomntana ntini uma senithole uxolo ukuthi nihambise umsola ku Lieutenant Colonel Rapado namhambisa na.
E re mishitse Maroka police station.
Yes, we took him to Moroka police station.
Yebo samisa eMoroka police station.
Okay. Am I correct, Sergeant Mohane, to say from the appearances as they appear that he was booked in the early in the hours? It means the suspect on that day he did not sleep.
Gora gore bona ba bolela nnete na ge ba re ka mokgo dilo di bonagalang ka gona jwalo ka ga ile gore yena o ile a ngwetswe gore o fitishitswe mo gare ga masa ra gore molato fatswa a se a robala.
Ngendlela obonakala ngayo ke uthi wakhishwa ngasikhathi sini bona sengathi umsola azange kuthole ithuba lokulala kunjani.
Ke a gana ka roba robetse kolong ya re ntse re tsamaya le ena.
I dispute that as he was sleeping in the vehicle as we were driving.
Hayi ngiyafika la ngoba ayilele emotweni ngesikhathi sihamba naye.
Okay. But he was not put into the police cells where he was allowed to sleep.
E fela ga se a tsentswe ka diseleng mo a ile madumelelwa gore a robale.
Futhi azange afake amaselile kufanele ulale khona.
As a court case, what is the basis for counsel to say that the accused was not put in a cell and allowed to sleep?
My Lord, I'm seeking clarity from the witness looking at the time when he was booked out, my Lord, from the cells and the time when he was booked back in the early hours. That's why I'm just getting clarity from the witness. Maybe he was allowed to sleep. That's why I'm just getting clarity from the witness regarding that.
As I
because he was
understand the
there.
evidence, these witnesses, they were from Bongani, am I correct?
Le lebeletswa Phokeng
Ka di 18
Or Chabani, whatever.
go ba Tlhabane
Okay.
lebeletswa kae?
That's our call. Okay, fine.
I do not recall.
Okay,
my
yeah,
lord.
continue with your questions.
Thank you, my lord. You can't answer that. You can't recall, or you remain with your answer to say he slept in the vehicle when you were traveling.
Le santse le yeme mo karabong ela ya lena ya gore o robetse ge bentse le reile.
Hona le mo re- hona le mo re mošeditšeng ka mogare a robala gannyane mara ke tsone robetse nako e kae.
There is a point where we took him back into the cell and he slept a bit, even though I do not recall how long did he sleep.
Oh, okay. I can refresh your memory because I recorded the entries. From Phokeng, he was booked out 8:15 in the morning and he was only booked in at 2:30 on the 19th of June.
Ba re batla le go potsa go bana ba di-wet fast go tloga Phokeng.
And then he was charged. He was
Ka
charged at,
8:15 go fitlhelela ka 2:30 ya masa.
yes. And then he was booked out at 4:50 after that entry.
Ba ntshiwa ka 4:50 ka moraga go ngwetswe jwang. It is correct.
Can you recall anything or you can't recall?
Go na le ntho e le kgonang go e gopola go baka le sa gopola.
Go gopola gore re mtsentšhitše diseileng ya re boa.
I recall that we had placed him in the cells when we came back.
Bile re mo ntšhitše ka diseileng gape re tsamaya.
And we took him out of the cells when we left again.
Yes. So if I understand what you are saying, so you would have booked him, you would have put him into the cells after 2:30.
Se se bolelang gore lena le mmušeditše diseleng ka mora ga seripa ka mora ga iri ya bobedi.
And he was taken out at 4:50.
La montšha ka metsotso ye lesome ka pele ga iri ya botlhano. That is correct.
So in other words, it means he was only detained for 2 hours. He was only put into the police cells for 2 hours.
Se se bolelang gore o tsentšhitswe ka diseleng iri tše pedi fela.
Ke nnete.
Okay. And he made the statement.
It's actually not 2 hours. We don't want to be pedantic, but it's more than 2 hours. 2.5 hours, minimum 2:25.
Manus, the witness can correct that. The witness is the one who knows better. If I'm not giving the correct estimate, you know how long was the suspect put into the cells.
Di ka lo magareng nako tšeo. 3 hours and 2.5 hours.
The time could be between 2 hours and 3 hours.
Okay. From my calculations, from 2:35 to 4:40, it gives me 2 hours 20 minutes.
Go ya ka yena ge a se tša dira di-calculation go tlogelela ka 2:35 go ya go 4:50 e mo nea di-iri tše pedi le metsotso e masome a mabedi.
We betile kgomonela again.
You have said it correctly. So
Thank you. And it is your evidence that when he was taken to make the statement, sorry, my lord, not that it, can I rephrase, not that it is your evidence. Am I correct to say that when accused number 2 was taken to Lieutenant Colonel Ropadu, he had not slept, he had only been kept in the police cells for 2 hours 20 minutes.
ke nnete gore molatofatšwa ge be a išwa go lephodisa Raphato yena ga se a robale o loketswe fela ka diseleng iri tše pedi le metsotswana.
Ngabe kuneqiniso yini manje ngithi-ke umsolwa So isikhathi angena ngaso emaseleni nokuthi athathwe kayiswe esekhishwe siyiswa ku-lieutenant Rapado, wayiswa nje wayehlala nje imizuzu amahora amabili nemizuzu.
Nka se ra robala ka ge ba isha diseleng ba ishwa ke maphodisa mo police station eo.
I cannot say he did not sleep because when they are taken to the cells, they are taken by the police officers from that police station.
Angeke ngisho ukuthi wayengadlanga ngoba uyiswa emaseleni bahanjiswa amaphoyisa lapho esileso station.
Okay.
Sorry, I don't want to interfere, okay? You see the defense that was put by Mr. Mngomezulu is that this witness, accused number 2, was never taken to Rapad. He was taken somewhere to be assaulted, choked, etc., etc., etc. Inanda comes there, opens the boot of the car, gives him documents, sign here, sign there, sign there. Assaulted again, then they realize, oh, something has not been signed. Then they take him to Morocco now. And when they get there, are you with me?
Yes, my lord.
These versions, I want to be fair to you, Mr. Mngomezulu, and you, they are mutually destructive. Because the way you are putting it, it appears as if you are not disputing the evidence of this witness. When in fact, according to Mr. Mngomezulu, he never ever took Mr. Ntanzi to Rapad. He met somewhere in the hospital, etc., etc. Keys were given, blah, blah, blah. Taken to an open space, assaulted. I'm just saying it.
Thank you, my lord. I was just referring the witness as to how the incident unfolded during the time when he was booked out up to the time when he was booked back in the early hours.
Okay, no problem.
Yes. I have not touched the issue of the accused and the Lieutenant Colonel Rapado. I'm just talking about the night preceding to that incident, my lord. And I did not get the answer.
It's a Karawayal Nabi.
Kana le rileng hapa ka re sa
By the
ba
way, what
disturb ka o sheletsa ka
What
ke
was your
kopela.
question as you have distracted me? May you please repeat the question?
No, I had said it means for the whole night the accused had not slept. If he had slept, he only slept for 2 hours that he was put in the cells.
Bona ba rile go ra gore bosigo ka moka mola tfatšwa ga se a robale ge ile gore o robetse yena go ra gore o robetse di iri tše pedi fela.
Futhi angisho ukuthi umsolo akazange alale kulobo busuku. Uma uvuthiwa kwazi ukulala wayalala amahora amabili kuphela.
Ga robetsa ra go robetsa na go eo ka ya 2 hours and 40 minutes, 20 minutes.
He slept, meaning he slept that 2 hours and 20 minutes that you have referred to.
Okay.
Wayalala wona wona nama-hours ukhuluma ngawo amabili.
And then on the 22nd of June 2020, when the accused was taken to court, he was taken not for Nongoma case. Am I correct?
Ra gore ka di 22 tša June molatofaditšwa ge se a išiwa kgotlatshekelo yena o ba sa išetšwe molatola wa Nongoma.
Which he was
Mhla
detained.
22 kuJune umsola umeseyiswa enkantolo wangayiselwa leli cala kaNongoma.
O be a tswaleletswe wona.
Lelo ale ayiboshelwe lona.
No we shejwe for poking.
He was taken for cocaine.
For okay.
Ayiselwa icala lasePhukeni.
Okay. And from the evidence of Jonathan, Mr. Buthelezi, and Mr. Buthelezi, they testified that they were asked by yourself on respective dates when accused number 1 was taken to make a statement to Lieutenant Rapado, and when accused number 1 was taken to make a statement to the magistrate, Ms. Cronje. Their evidence is that they were requested by yourself to escort you as you were traveling.
Jonathan Buthelezi.
I'm sorry, accused 2, my lord, not accused number 1.
Jonathan Mtsheli bona ba boletse botlhatsi ba gore ba be ba boditswe ke lena gore ba sepele le lena ge be a ilo dira statement sela go magistrata e leng gore molatofatša wa bobedi e leng Ntanzi o be a ilo dira confession ye we goba statement seo.
Usho ukuthi ukwazi okuvela kuJonathan novela kuThelezi ukuthi umsoka wayeswa phakathi isa statement futhi wayeswa futhi magistrate ukuthi ayobhalisa statement nokuthi ke nina wena wabacela ukuthi bazoniphelezela.
Re ke tlhalosetsa jo goro ka tsela e.
May I explain it to the court in this way?
Ekurhuleni Metro Police Department e khopetswe ke Brigadier Gininda le di supervisor tja Ekurhuleni Metro Police Department go thusha re go sepedisha di suspect ja rena ka yona molato.
The Ekurhuleni Metro Police Department was requested by Colonel Gininda and the supervisors to accompany us as we were traveling with the suspects in this matter.
Okay, in other words, you are saying you were never involved in the request that was made requesting the members to give escort to yourselves.
Kamanju amang lena le re ga senke le be karolo ya kgopelo yewe ya gore le kgopelo gore batho ba o ba tlo sekela le lena.
Ka ge shetse ba ba file tumelo la go shumishana le rena.
As they had already given them the right to work with us.
Ba ile ba re fa tumelo la gore rena e be re ka mo fase mo re kana ra founelana ge go na le mshomo tshwantse ro dira.
And they gave us the right to contact each other if there was any duties that we were supposed to do as we were working on the ground.
Okay, so as you had been given a right to communicate, were you given specific members to request from the metro each and every time when you needed their services?
Ba ile ba lefa batho tsoko gore lena ga ile gore le tlhoka tshumishano le bolele le batho ba re. Correct, we were given that particular group.
In respect of accused number 1, in Albertine on the 30th of May, were you also present? In Albertine recipients?
Albertine ka kwa ka di 30 tša May go ya le molatofatšwa wa mathomo.
On the 4th of June. On the 4th of June.
Ba re ka di 4 tša June.
Actually, the 5th of June.
Yes, it is correct.
Who arrived first at the Albertine station between yourself and Jonathan and his crew?
Go fitlile mang pele magareng ga lena le Jonathan le setlhopha sa gagwe kwa sepodising sa Albertine.
A ke sa gopola botse re fitlhela mampela a ke sa gopola botse mara bona ba fitlhile re rena fitlhile.
I do not recall who arrived first. However, they arrived and we also arrived.
Okay. Do you recall as to where were they waiting, Jonathan and his team?
Jonathan le setlhopha sa gagwe ba eme kae?
Ya gopola.
Yes, I do recall.
Where?
Ngandlela-
Uyakhumbula yini ukuthi uJonathan nethimba lakhe babemephi?
ngandlela ka police station.
outside the police station.
Babeme ngaphandle kwe-police station.
Thank you, my Lord Medical. Just bear with me. Thank you, my Lord. I've got no further questions.
Okay. Yes, Mr. Oh, you said you were waiting. Mr. Baloyi, any re-examination?
There's a quick piece, my lord. You were asked by counsel for accused number 1 and 2 regarding the appearances of the accused in Boksburg.
Botsitswe ke ramolao wa molatefatso wa mathomo le wa bobedi ka go tswelela fua Boksburg.
This is now as far as Exhibit E is concerned.
Okokuqala nokwesibili mayelana nokuvela enkantolo yaseBoksburg kamsola wesibili.
Ba re go ya ka botlhatsi bola ba E di dise exhibit E
Yes,
of
Exhibit EE
EE
Mamela ne-exhibit EE
on the 27th of October
ka di 27 ja October
27 October
2020
ngwageng wa 2020
ngaka ba 2020.
as to whether you had permission from the station commissioner to postpone to postpone accused number 2 to Valeria police cells.
gore lena le be le filwe tokelo ke station commander gore le ka molatofatswa wa bobedi yena le ka moisha diseleng tša Deleria
Okubuza ukuthi ke nanayo yini imvume yokuyisa amasola emaseleni asevaleriya ngokuya kwimvume nayithola ngokuya ka-station command.
In that,
that is correct.
Yebo kunjalo.
Yesterday we handed the original of exhibit EE
maobane re fane ka tokomane yela ya EE
Zolo-ke khona-ke i-exhibition iyona.
Bakgopela lebadi.
I just want to draw your attention to a letter my lord, the letter would appear right almost in the middle of the proceedings. If you can just place just the contents of the letter on record.
ba re ba nyaka gore le ye go lengwalo leuwe le lebale le godimo le kgone go kwagala.
Yena ukuthi ngifundele yoncwadi ngifundele enkantolo.
language where the station commander South Police Service Valeria
Bale ukuthi station commander wesiteshi sase-Valeria
magodimo nothi inquiries Colonel Toka
bale lapha ngenza ukuthi inquiries.
On top it's written inquiries Colonel Toka
gomme ba e addressitse the magistrate senior public prosecutor Boksburg Magistrate Court Boksburg
and it was addressed to the magistrate senior public prosecutor in Boksburg Magistrate Court
Iqondiswe ku-imantshini enkulu yase-Boksburg.
Permission to place a suspect at Valeria police cells.
And it reads as follows. Permission to place suspect at Valeria police cells.
So ifunde kanjena ukuthi imvume yokufaka umsola emaseleni asevaleni.
Here, point number 1 is here with permission to place under mentioned suspect at Valeria SAP cells for further detention.
Point number 1 is read as follows. Here with permission to place under mentioned suspect at Valeria SAPS cells for further detention.
Uqala ukuthi isicelo sokufaka umsola emaseleni asevaleni.
Omega Mama Shakaning in which case number 636 of 10/2014.
And in the box is written case number 636 stroke 10 of 2014.
Lapho ubhalene nenombolo yecala 636 stroke 10 stroke 2014.
Umele Shakana la latela lengwe gore name of a suspect Bongani Ntanzi.
Second block, it's written name of the suspect, Bongani Ntanzi.
Kulandelayo kubhalwe igama likamsola uBongani Ntanzi.
Shakana la mafelelo in which Colonel B.N. Gininda.
The last block is written Colonel Investigative Officer, Colonel B.N. Gininda.
Ekugcineni kubhalwe ukuthi umsebenzi uLieutenant Gininda.
Point yabobedi in which permission is granted by Colonel Toka SAPS Valeria.
Second point, it's written permission is granted by Colonel Toka SAPS Valeria.
Kuke ekugcineni imvume yanikwa uLieutenant Toka wasesitishi saseValeria.
Mofase assign in station commander Colonel SAPS Valeria MS Toka.
And underneath the sign is also written Colonel Station Commander SAPS Valeria MS Toka.
Enzathi siyasana ukuthi station commander saseValeria uLieutenant MS Toka.
Kamofase amala date 2020 of 10/27.
Underneath it's written a date 2020 of 10/27.
Uthe enzathi wasefaya nosuku umhla 27 October 2010.
A copy is certified again na PV Mohani, custom beside leg of the court of Boxbeck Police Station.
And a copy.
Court, Boxbeck Court.
A copy was certified by myself, Mr. Mkhani, with the stamp of the clerk of the court.
Nake ngahamba lapho isiqiniso sasenkantolo sokuthi lencwadi yiyo ngempela isiqiniso sasetshenziswa sasenkantolo yaseBoxbeck.
That is all.
You were also asked by counsel for accused number 1 and 2 as to how you know Mr. Mjiako.
Ilela botšishwa gape gore Mr. Mjiako yena le motsebile jwang botšishwa ka ke mmele wa molatofatso wa mathomolo wa bobedi.
Umele kamsolo kuqala sibili babuzayo futhi ukuthi mazi kanjani uMjiako.
And you then gave an explanation. Can I once again ask you to turn to the transcribed version of Exhibit EE on the 27th of October?
Balere go mola ye leng gore e typilwe ya di 27 tša October yona ye ya EE.
Manje
La fana ka tlhalošo.
exhibit ila akhombisa ukuthi kwakuqoqwe phansi.
Yes, I can see
Who
it.
appeared for accused number 2?
Ke mang o be e le mmele wa molatofatso wa bobedi?
Ubani owanele umsolo wesibili?
In which Mr. Ntokozo Mjiako attorneys.
It is written Mr. Ntokozo Mjiako attorneys.
So lapha-ke uNtokozo Mjiako owasefemini labameli lakaMjiako.
The case was then postponed to the 27th of November, the correct 2020.
molato o bo o ile wa hlekisetswa morago o issuea go di 27 tša November 2020 go jwale.
Leli cala ke lesephethelo ngomhlaka 27 November 2020 akunjalo.
On the second page.
Mo pageng ya latela.
Futhi sinelandelayo.
Ke nnete.
It is correct, I confirm.
Iqiniso.
Who appeared for case number 2?
Ke mang o be a emetse molatofatšo wa bobedi?
Ubani ke wayimela umsolo wesibili?
Isangwetswe Mr. Mejiyako gape.
It is still written Mr. Mejiyako.
Kusabhalwe yena uBabujiyako.
Thank you.
Ba leboga.
Are you through with that letter, Mr.?
There's a formal letter that is on record. If I can just ask you to put that, the contents thereof on record.
Ba re go na le lengwalo shile ba kgopela gore le lebale le tle le kgona go bala.
Khona ke incwadi ke engifisa ukuthi uyifunde ukuze iqoqwe phansi.
Mo mengwalong e megolo godimo ga letlakala e ngwetswe Mejiyako Attorneys Incorporation.
In bold, on top it is written Mjiyako Attorneys Incorporation.
Ngamagama ke amakhulu ubhale lapha phezulu ukuthi abameli bakwaMjiyako.
Walatala mengwalo ring the Director of Public Prosecutions, attention Advocate Jibaloi, per email on Ngasibali.
Then it is written the Director of Public Prosecutions, attention Advocate G. Baloyi, and an email address. And the witness says he would not state the email address.
The
Ke
date.
kubhalwe ke
Date
ukhoniswe kubashushisi lapho kubhalwe khona ukuthi ukhoniswe ushushisi ku-Advocate G. Baloyi.
Dating was 3 March 2021.
It is dated the 3rd of March 2021.
Ukuthi kubhalwe usuku lomhla 3 kuMashi 2020.
Yoneba lakasilai dear says.
It is written as follows. Dear says,
Kubhalwe ngeyethu abanumzana.
Yangwala gape ka mengwalo e mekutunyana RE/Ntanzi for Soloras Case 636 of 10/2014.
also written in bold, RES stroke Ntanzi for Sloras case 636 10 of 2014.
Kubhalwe ke lapho ukuthi sihloko sithi Ntanzi icala lasePretoria 636 of 10 of 2014.
Point number 1, we confirm that we act on behalf of Mr. Bongani Ntanzi, who is accused number 2 in the above matter.
When number 1 is read as follows as the witness has just read it, my lord.
Kubhalwe kanje ukuthi thina simela uSandiso Ntanzi kuleli cala.
And then, immediately after the last court appearance, Mr. Ntanzi withdrew our mandate as his attorneys of record and opted to be represented by the Legal Aid Board.
That is the second point, my lord.
Iphuzu lesibili ke lithi ke hayi uSandiso Ntanzi ke wase uyasikhipha njengabameli abamele waseqoka ukuthi uzonimelwa abakwa-Legal Aid Board.
We also not been receiving financial instructions from Mr. Ntanzi.
Okwesithathu ke kuyasho lapho ukuthi cha asizange sikhokhelwe.
Point number 4, Mr. D.N. Mjiyako, who has previously appeared on behalf of Mr. Ntanzi, is no longer with our firm and has joined the Cape Bar as a people advocate.
Manje futhi wabhala ngephuzu lesine ukuthi uDM Mjiyako owayemele umsola ngalela usashiya kuleyo firm leyo wasuka wayesebenzela eCape.
I am mindful of our duty to formally inform the court about these developments and to withdraw as Mr. Ntanzi's attorneys of record.
Manje wasecela ukuthi ufisa ukuthi inkantolo yazi ngalokho ukuthi ke share phansi uba abameli kuba
However, due to a family bereavement, I am unable to make it to court on Friday, 5 March 2021, and my colleagues are out of the province.
ushukile ngeshwa ke ikhona ukusuvelele ekhaya ngikwazi ukuthi ngomhla 5 kuMarch ngiyovela enkantolo ukuthi ngiyosichaze ngoba kodwa ke futhi ke okunye ukuthi abekho abanye ngisebenzisana nabo.
Point number 6, may I therefore humbly request your assistance in informing the court on our behalf about this development and to request that our non-appearance be excused and our withdrawal of attorneys of record be confirmed.
Manje ngicela kwazisa inkantolo ngaloko futhi ucela usiphindisele inkantolo ukuthi sesishiya phansi njengobumeli beka so.
Point number 7, thank you in advance for your kind assistance herein.
Sizobonga usizo lwenu mayelana nalo.
Yours sincerely, Mijaka Attorneys Incorporation, DL Chia.
Thank you. It was put.
No. Put in the practice number. Remember the allegations.
Yes.
Subtle allegations that this gentleman is a fly-by-night cancer or a team.
Yes, just put the practice
So
number.
put the
practice number.
legal practice number.
Mofasi Inuiti legal practice council number
At the bottom it is written legal practice number
18209.
Manje la kufanele inombolo yabo yokugunyaza ukusebenza njengabameli ithi 18209.
CIPC reg number
Balothi CIPC reg number
2017 stroke
2017 stroke
149
149
229 stroke 21.
stroke 21.
Rumegamo Inuiti vet number
then it is also written the VAT number
Ukade VAT number
451028
451028
4914.
4914.
Barbara Leboga.
Mr. Baloi, put the address of this attorney on record because I see it here.
Please.
Barbara Lekabala le address.
Because we don't know whether he has an office or not. When the evidence was unfolding, it doesn't exist apparently.
Okay. Put.
Address agabela ke sela e
Ikesi la ikele la ke lifundeka kanje.
The address is read as follows.
10 8th Street, Melville, Johannesburg.
10 8th Street, Melville, Johannesburg.
Well, phone number.
Should I read the phone number
code?
as well, my lord?
Yeah, the code.
Telephone
Postal code.
Our code is 2109.
2109.
Telephone number
Cingo
plus 2711
plus 2711
482
482
2325.
2325.
Email address
Email
info@mijiago.com.
info@giago.com.
Website
That's the website.
www.mijiago.com.
www.giago.com.
Directors, is it necessary?
Yes, it's not necessary. But
Hey, it's necessary. What do you mean it's necessary?
no, we're just going to refer to the senior
Because
associate
this gentleman practices in partnerships.
as a good.
It's not a sole practitioner.
As a good, we just wanted to put the senior associate on record. Who's the senior associate?
Imam Womogolo.
Obani ababambisene nabo abaphezulu.
Inuiti senior consulting attorney.
Are you referring to the one that is written
No,
senior?
senior associate.
Directors.
Well, we just mentioned the directors. The directors.
Okay, just.
We don't have to mention the qualifications. That the directors of so and so and so and so and so and so.
Barley the director.
Senior associates. So and so.
Director Iridineo Chia, Managing Director, LLB Limpopo, Katiso Mphahlele, LLB Vets, LLM Labor Law UP, Certificate in Law Dispute Resolution Stellenbosch, Senior Associate in Tokozo Mchiako, LLB Vets, PDM Vets, Natalaki Senior Consulting Attorney Melanie Naidu, BA Vets, LLB Vets, LLM Vets, Advancing Diploma in Banking from Bankers Institute of South Africa, Junior Consulting Attorney Faith Huntley, LLB UNISA.
Thank you. It was put to you by counsel for accused number 2 regarding exhibit RR. There is now the court proceedings in Phupkeng.
Moleledi wa molatufatso wa bobedi yena o ile a bolela ka botlhatsi ba RR e leng dilo tse di diragetseng kgorong ya Phupkeng. That is correct.
It was put to you that accused number 2 did not appear in court on the 22nd of June 2020.
Ba ile ba le botsa gore molatufatso wa bobedi yena ga se a tswelle kgorong ka di 22 tša June 2020. I do recall that.
If I can ask you to turn to exhibit RR.
Barlego botlhatsi ba RR. Yes, I am in possession of it.
If you turn to the 4th page from the beginning. Yes, can you just place on record what's written there?
P04.
On top it is written P04.
A171/20.
A171/20.
On 13 of 7/2020. On 13/7/2020.
On 13.
No,
Yes.
the 4th page from the beginning. Yes, can you just put that on record?
Major Agenda 29/6/2020.
Can you give me the date again?
29 of 6.
29/6/2020.
Legal aid in custody, no bail.
Legal aid kungaphakathi akanayo ibhili.
And what is your recollection? Was as far as the presence of the accused at court on the 22nd of June 2020 is concerned?
Lena kgopolo ya lena e reng ka go tswelela ga molatofatso ka di 29 tša June 2020.
Wena kumlana ngomfika ngomsole enkantolo mhlaka 20 9 June 2020.
o latofatša o tšweletše pele ga kgoro ka yona di 29 June o išitše ke nna ka sebele.
The accused appeared in front of court on the 29th of June, and I personally took him to court.
No, we're talking about the 22nd of June.
22nd, yeah, 22nd, oh, yes.
On the 22nd.
So
Sorry?
why the record on the 27 June 2020? What do I happen to say?
Right, then on the 29th of June, just the following page, 29 June 2020,
At the 29th June 2020.
And on 29 June 2020.
just plays on record what's written there by the magistrate.
And today, like Thulani.
Yes, 29 June 2020.
Agent 29 June 2020, legal aid in custody, no bail.
39 June 2020. Misola ngaphakathi kumele illegal aid futhi akanayo.
Yes, then the following appearances on 29 June.
Year lateral, the 29th June.
Here the page 4, the 13th of 7, 2020.
No, 29
of June. Where is it?
It's written page 3 at the top.
Page
Page 3.
3.
Page 3.
There is no page 3 on this document. This one does not have page 3.
This was the entry there.
Unveiling.
Which is page 3, A171/20.
Page 3 number
A171.
A171
Stroke 20.
20.
In which on the 29th of 6, presiding officer Miss A. Rose. Miss A. Rose.
Rose.
Prosecutor Mr. Stroke Mr. Mohapais.
No, 29 June is written page 3 after.
Yeah.
Yes.
Yes, I'm reading.
He was the witness on 29.
Oh, there, okay.
That on record.
But never mind the year.
Or Yamatomo in which your court not working.
First one is written court not working.
Acute not brought in court, isolation for COVID-19. Agent to the 13th of July 2020 in absentia in custody, no bail.
July 2020. Engaphakathi esithuthini kodwa ke lihlalisiswe engekho.
Do you remember this appearance of the 29th of June 2020?
Isayokula taba ye ya di 29 June 2020
Ukhumbula
gore asiyatholele.
June 2020.
Yes, I do remember it, my lord.
Yebo ngiyakhumbula.
Do you remember why the accused was not before court on the 29th of June?
Ya gopola gore go bane
2020.
molatofatso o ba se go kgorong ka di 29 June 2020.
Uyazi ukuthi yini indaba umsola engekho enkantolo ngomhla 29 June 2020.
Kiagopola gare go bona le a case ya COVID-19 Valeria police station.
Yes, I recall because there was a case of COVID-19 at Valeria police station.
Yebo ngiyakhumbula ngoba kuthiwa ngayela wathola ukuthi kukhona owayephethwe isifo sobhubhane se-COVID eValeria.
Thank you. Counsel for accused number 1 and 2 also referred to exhibit VV1.
Wa molatofatso wa mathomo lo ba le VV1.
It's a report from Tlhabane.
Ke report ya go tswa Tlhabane.
So ummeli kaMsolo uqala sibili
Dental services.
VV1
yona she.
in front of me.
The date is the 22nd of June 2020.
Date ke di 22 tša June 2020.
Nnete.
That is correct.
akunjalo ukuthi usuku wamhla 22 kuJune 2020.
You mentioned in cross-examination by counsel for accused number 1 and 2 that you took accused number 2 for this dental examination after the court appearance on the 22nd of June 2020.
Le ile la bolela re be le botšwe ke ramolao wa molaofatšo wa bobedi gore le nna le ile la mmeša ba ile mo tlhola meno.
Ke nnete.
It is correct.
Uthiwa-ke ummeli kaMsolo Sibili wathi wathathwa wayiswa kudokotela wamazinyo emva kokuthi avele enkantolo thiya.
What was the purpose of this examination, the dental examination?
Lebaka la gore a ile tlholwa ka meno e be e le eng?
Kwakuyini ke isizathu sokuthi ayohlolwa amazinyo?
Re ile re dutse re phenya molato wa 636 wa kry-a le gore mo senepe se ba montšhintše go sona o ba na le gold o tswile motho a rona le gold so be re tšhaka nna sala ba le gold na mo menong.
Whilst we were still investigating the matter of 636, there was a picture which depicted a person that had a gold tooth, my lord, and we went to see if he has ever had a gold tooth before.
Manje ukuphenyo lethu kwatholakala ukuthi khona isithombe la kuvela khona ukuthi wayenezinyo elinegolide. Manje sasifuna ukuthi simise lapha ukuthi kuyohlola ukuthi wake waba nalo yini izinyo legolide.
Can you just place these details under other details on record?
Nke le bale mola mo go ngwetsweng other details le di bale.
The other details with you. Look how too short the more.
Can you please show me where, my lord?
Patient report.
Or patient report.
Patient, okay. Further details.
Further.
Yes.
Patient report have been admitted for a heart condition in 2014.
Umsolwa-ke wake wathathelwa wahlolwa ngokuthi kwaba nesifo senhliziyo ngo-2014
following mining accident.
emva kokuthi-ke kube nengozi yasemayini.
If I can ask you to turn to Exhibit JJ.
Ba kgopela gore le ye go botlhatsi ba JJ. I do not have JJ in my
Copy. There on the SG, can you just put in record what Ms. Cronje wrote there?
ba shimo le ba botsa gore Miss Cronje o be a ngwetseng.
Cela utshele inkodo ukuthi Miss Cronje lapho wayebhale.
Ke bala ka moka
There where there's a star.
Oh.
Bathi la kunenkanyezi khona.
I do not want to report any medical conditions or injuries.
Yes.
Bathi akufisi ukuthi ngibike ngikulimala nokuthi lethe umbiko ngizempilo.
Except had a heart problem.
Manje ukuthi wakwaba nesifo senhliziyo.
Thank you.
Sorry, that's annotation by Ms. Cronje. What date was it made? By the way?
It was on the 24th of June 2020.
24th of June. Okay.
Exhibit JJ.
2020. Give it J. JJ. That was the pro forma.
The pro forma.
Okay.
Now, if I can ask you to turn to page 2 of Exhibit VV1, the dental report.
Maria page 2 with has a BV1 yellow report here with follow ameno.
Passing this BV1
There's a clinical examination. It was put to you by counsel for accused number 1 and 2 that accused number 2 was tortured, assaulted, and chewed on the 19th of June 2020.
Baile ba le botsa gore mona tfatwa yena o ile tshariwa a betwa gape a ka 19 botsa June.
So umeli kamsolo sibilo wa wothi wahlukunyezwa washaywa wasefakwa neshogu mhla ka-19 June 2020.
During the oral examination, what was the finding regarding the general appraisal?
Rene a tlholwa ka menong bona ba boletse goreng
General
Mehlola ke kwa bikwa kwathini
general appraisal is normal.
ke konke kulungile.
Yes.
TM joints normal.
Ama-10 joints akahle.
Lymph nodes normal.
Athi ama-lymph node alungile.
Intraoral exam normal.
Bheka la ngaphakathi kulungile konke kulungile.
Lips and buccal mucosa normal.
Wathi ke isikhumba phakathi komlomo neindebe zomlomo zikahle.
Oropharynx and tonsils normal.
Wathi ke ama-tonsil nala qoqoqo konke kulungile.
Palate normal.
Ke ngaphakathi emlonyeni ngaphezulu phahla lomlomo lona kulungile.
Floor of mouth normal.
Thile lana ngaphansi emlonyeni konke kukahle.
Tongue abangwala silo.
on tongue they did not
Abakhulu
cheat anything.
mangalithoke ngoli
Elatela ngiri gingival and periodontium. Yangwala abnormal marwangwala ginginal recession. Actually, wawali no 41423.
And it is written ginginal recession of 41 stroke 42 stroke 3.
Yes.
Theke igingival ne periodontium konke 4 gingival recession of 4142 interdental spacing nakhona 112 to 122
Megamorphosis, yangwala angle classification class 1. And then your teeth chart, interdental spaces, your 11. 0.12,21 come class you have 23,12 very category like so na
And on the teeth chart it is written class 1 interdental space 11 arrow 12 comma 21 22 arrow 23 comma 12. And it seems like there are letters that were cut, my lord, as the witness cannot see them properly.
lapho ukhombisa ke ukuhlala kwamazinyo ukhumbula ke isikhala ke siphakathi namazinyo kuthiwa iphakathi nesikhala phakathi kwezinyo 11 lokufika kwelesibili nesikhala esingemva ka-21 bese kuba nesikhala phakathi kwezinyo lemashumi amabili nezinyo lemashumi amathathu kwase kubekwa ke nesikhala ngaphansi kwezinga leshumi nambili kodwa khona okunye kungaseceleni okugcineni kungasabonakali kahle.
The God, please, my Lord, this is quarter to 4, way past our normal time of
We're still
adjournment.
going to go on.
Can we adjourn about 1 or 2 further questions? Maybe then adjourn until tomorrow.
Tomorrow. Okay, any objections? Adjourning at quarter to 4?
Up to.
There is none.
My Lord, may I make a request on the, I'm not intending
You're
to,
not?
I'm not intending to interject on the evidence that the state is busy with. I believe the document that the state is busy with was not admitted under section 220.
Which document is that?
The one for medical examination of the accused.
The one which? The one of the dental examination?
That's correct, my Lord.
You told me that you agreed.
No,
You,
I just consulted.
Mr. Baloy, didn't you tell me that?
It was sent out by the defense, my Lord, and we said we don't object on one specific case.
So you are objecting to its handing in?
My Lord, it related to the date of the 22nd of June.
Yes, but the point
not
is,
on the
are you
contents.
objecting to the admission of that?
That's correct. That's correct, my Lord.
You are objecting to it,
Yes, correct.
but it's before court. You can address me tomorrow.
That's correct, my Lord. I'll do so.
And who handed in this document?
It's the defense, my Lord.
Yeah, as I recall, Mr. Mngomezulu himself. Okay. Can you number that order, that court order? Give it a citation. I don't know exhibit what. Are you with me?
Yes, it will be Exhibit W.
Exhibit
WW.
Exhibit WW. That is the apparent confidential report of the sergeant. Are you available tomorrow, sir? Okay. 10 o'clock tomorrow.
In every such case, the suspect must be interviewed. In every such case, the suspect must be interviewed and this statement must be completed. This statement must be completed every time the suspect is interviewed, irrespective of whether the suspect is arrested or not.
Zonke isikhathi umsolo uma kufanele ukhulume naye kufanele lesi statement sigcwaliswe. Le statement ke kufanele ukuthi sifanele sigcwaliswe ngazo zonke izikhathi lapho ke umsolo ukukhulunywa naye. Ungabhekiwe ukuthi umsolo useboshiwe noma akakaboshwa.
Paragraph B.
Paragraph ya boraro.
Paragraph B.
B.
Yes.
The member who conducts the interview with the suspect is to complete the statement fully in the presence of the suspect.
Kuthiwa ke ozobe khuluma ke nomsolwa kufanele agcwalise ngokuphelele istatement lesi phambi kukamsolwa.
Okay. Paragraph C.
Paragraph C.
If there is not enough space on any of the pages, the member must continue on a separate follow page. This follow must be signed by a member, suspect, interpreter, and the commission of oath, and must be attached to the statement.
So lana ke uma ingekho indawo eyanele ekhasini iphosa lifanele liqhubeke libhale kwelinye ikhasi leli khasi lifanele lisayindwe futhi ilona liphoyisa umsolwa uToliki futhi kube ne-commissioner of oaths and futhi lifanele linamathiselwe ku-statement.
Paragraph D.
Paragraph D.
The Commissioner of Oath must sign on every page of the statement.
Kuthiwa-ke uCommissioner of Oaths kufanele asayine wonke amakhasi statement.
Yes, paragraph.
The Commissioner of Oath must sign on every page of the statement. If the suspect is a child below the age of 18, the parent, guardian, and appropriate adult must sign every page of the statement.
So, uma kuwukuthi ke umsolwa useyingane engaphansi kweminyaka eyishumi nesishiyagalombili umzali noma omgcinayo noma ke umuntu omdala okhona ufanele asayine wonke amakhasi estatement.
As you could please, my lord, sorry to interrupt my learned friend. The state objects against this line of cross-examination by my learned friend. Firstly, we don't see what the relevance of this cross-examination is. Secondly, the witness said yesterday that the interview on the 17th was not a warning statement. And if one looks at what the exercise that my learned friend is busy with, this regards a warning statement, unless if my learned friend intends on canvassing a warning statement of accused accused number 2 with the witness. But if one looks at paragraph 1, it states clearly there that this form is applicable in the case of a warning statement, and that in that case, the station commander must consult with the prosecutor. So whatever follows, my lord, is subject to the obtaining of a warning statement and not an interview that the witness has testified about.
Yes, ma'am.
Thank you, my lord. My lord, I think I've clarified this yesterday, my lord.
No, clarify it again because Mr. Baloy is now objecting.
Yes.
You remember my comments yesterday?
Yes, ma'am.
Yes.
My lord, I am not referring the witness to this paragraph because I'm saying that this document was signed or completed by any of the accused.
Fine. What is that document?
It is a warning statement, my lord. And
Okay, fine. Accordingly,
it's the instructions that are given, yes.
when one wants to take a warning statement,
For the police officer to record when he's interviewing the suspect, my lord.
is it for an interview or for the taking of a warning statement?
It is for an interview, my lord. That's why I read paragraph 2, because
Okay,
it says the
fine.
member, paragraph B, my lord. It says,
Let's start from the beginning. What is that document for? Because Mr. Baloy says it precedes the taking of a warning statement, and you are saying it's for an interview.
my lord, if I can just repeat myself, my lord, yesterday the witness testified that they were interviewing the suspect in the
Right, fine.
courtroom.
Yes, yes.
Then my question was, my lord, was it recorded? Then I said, where was it recorded? Then I went back to this form to say, this form says the member who conducts the interview with the suspect has to complete this statement fully in the presence of the suspect. And
Okay.
paragraph A, my lord, says, irrespective of whether the suspect has been arrested or not. In other words, my lord, whenever there is an interview between the police and the suspect, that interview has to be recorded because there are allegations, there are constitutional rights that are explained by the police officers at that time.
Fine. And this form, what is it for? The very form. Is it for an interview?
It's for the statement regarding interview with suspect. It's written clearly on the instructions, my lord. In statement regarding interview with the suspect.
Yes, Mr. Baloyi.
And as a court, please, my lord, this is where, with the greatest of respect, we submit that my learned friend misses the point.
Why don't you bring, okay, you know what,
Yes.
just bring me the law,
Yes.
okay, because you're
Yeah.
at different
Yes.
poles.
Yes,
Can you
but-
give me the authority you're relying on?
Yes.
And please, Ms. Mshololo, give me the authority you're relying on.
Yes,
Can you adjourn for that?
Yes, but can we just make this one point before we adjourn, my lord? Just this one point. If one looks at paragraph A, it says clearly, the station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement.
So the prosecutor must also be involved.
Yes, and this is, the emphasis must fall on warning statement. The station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement of the suspect be obtained. And secondly, it says in every such case, in other words, in every such case where a warning statement is required. It doesn't refer to any interview with the suspect. And my learned friend is now opines that in every instance, when a police officer conducts an interview with the suspects, then this process must be followed. It's only in the case of a warning statement.
And that is, that, as I understand the law, that precedes the charging
Yes.
of the suspect.
In-
Okay, can you get me the law so that we don't argue in a vacuum?
As the court.
How long do you want me to adjourn?
My lord, maybe 30 minutes because I've already have the authorities. I'll just make the copies.
Do you have any authorities for yourself?
we still have to look up, but it shouldn't take that long.
Okay, 45 minutes. Yeah, what are we
we
busy
were
with?
busy with a questioning or interview that Sergeant Mohani conducted with a suspect.
Yes,
And
in the boardroom.
yes, in the boardroom. In other words, we're not busy with the taking of a warning statement,
Yeah.
but just merely an interview, an informal interview that a police officer had with his suspect.
Is that the background to the
Yes.
issue?
Indeed, ma'am.
Yes, Ms. Mshololo, let me understand you. What are we dealing with?
My Lord, we are dealing with the interview which took place between the suspect and the witness at the boardroom.
Right?
Where,
It's an interview.
it's an interview.
Yeah, what about it?
Yes, then my Lord, my submission is that because the witness said he explained the rights, he explained the allegations, and the accused responded. Therefore, that interview ought to have been recorded.
Right?
Yes, my Lord, that's
If
where
it's
we
not
are.
recorded,
It's my submission, my Lord. The court can make a ruling.
yeah, fine. Is that what you are dealing with, and is that what your colleague is dealing with?
That's what.
Now, how does this form come into play?
My Lord,
This form which you say the court must peruse.
it's because, my Lord, this form says statement regarding interview with the suspect. Hence, I referred this witness to that form. And it says, my Lord, on the first page, statement regarding interview with suspect, paragraph 1, my Lord.
Oh, you're reading paragraph 1 where it says the form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue
Yes.
on a folio attached to the folio of that page.
Yes.
And folios must be signed by the suspect, the interpreter.
Yes.
So you are saying this form is applicable, in other words?
My Lord, that's my respectful submission. my
Okay,
Lord,
you want me
say-
to rule on that?
To say during that interview,
It must be signed, the form must be signed according to you.
it must be recorded, my Lord.
Yeah.
Although, my Lord, I am not saying that the witness was bound to use this as its.
No, let's have, the
As-
submission is that it must be filled, this form, or what is your submission?
Yes, it must be.
It
My Lord,
must be filled.
My Lord, can I just refer this honorable court to just one judgment?
Which one is
I'll be
that?
quick. I'll be quick, my Lord. I won't waste the court's time.
Which judgment is that?
It's the Henry Foster and the Minister of Safety and Security. It's judgment by,
Others.
yes.
I've read this judgment.
Yes, yes.
It's about damages,
Yes, my Lord.
unlawful arrest, and the assault of a suspect who subsequently, obviously, the charges were withdrawn because there was not sufficient evidence.
Yes, my Lord. But there's a principle that I want to bring it to the attention
Which,
of this
yeah, okay,
court.
fine, bring it. Which principle is that?
Thank you, my Lord. On page 23, paragraph 28.
Wait, I'm going there.
Yes,
Page. Wait.
page 23.
Wait. Page 23.
Yes. Page 23. It's paragraph 28, my Lord.
Paragraph 28.
Yes.
Yes, put it on record.
Yes, my Lord. Paragraph 28, under warning statements, my Lord, it says, express provision is made in every warning statement in this court's jurisdiction for the completion of a warning statement each and every time that a suspect is interviewed. Paragraph 29, the constitutional protection provided for in terms of Section 35 of the Constitution to arrestees is embodied in this principle. There is no justification for any interview with a suspect who has been arrested or called in for questioning to take place without a warning statement being completed. Paragraph 30, my Lord. The very term warning statement indicates that a person is a suspect and has been warned of his rights, and in particular his rights to remain silent before any such interview may take place. Paragraph 31, it serves no purpose to attempt to recognize that an arrestee is not obliged to say anything, make any admissions, or answer any questions unless he is specifically forewarned of these rights and signs in the warning statement that he has been so forewarned prior to any interview or interrogation taking place. My Lord, I will skip all these paragraphs and then just go to paragraph 33. Oh, sorry, my Lord, I have not finished. Yeah, I'll skip this. And then paragraph 34, my Lord, the next page, on page 24, which says, it was startling to hear that both defendants' witnesses, who were experienced policemen, believed that they were entitled to question a suspect or arrestee at any time that they wish to do so without being compelled to complete a warning statement. And the last, the cover, and on every first page under the insignia of the South African police statement. The statement regarding interview with the suspect. This form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on the portfolio and attach the portfolio to that page. Folios must be signed by the suspect, interpreter, deponent, and commissioner of oaths. Thereafter, my Lord, on the same paragraph, the interviewing police officer is required to record that he has informed the suspect of the allegations, that he is investigating against him, her or her, to ensure that he understands the allegations. There are numerous introductory paragraphs and forms that require completion. The suspect is entitled to make, or if he wishes to do so, whereafter both suspects and the member of the SAPS are required to sign the document. All of the constitutional safeguards provided for in respect of arrest, accused, and detained person are contained herein, and the document sets out each and every step that must be followed in completion thereof. Paragraph, this is the second last paragraph I'm referring this court to, my Lord. There is no basis in law on paragraph 19, my Lord. Paragraph 39. Yes, paragraph 39. There is no basis in law of fact to conduct any type of an interview or interrogation without completing such a document. Any attempt to do so will render the arrest and detention of the suspect not only unconstitutional but unlawful. I am fortified in my view that the arrest and subsequent detention of the plaintiff in this matter was not, this is for the judgment of this case, my Lord. But can I just read it to complete the paragraph? The matter was not only unconstitutional but unlawfully because the defendant's witnesses testified under oath that they were of the view that they were entitled to interview and interrogate the plaintiff without having completed such a document. This can never be the case. The express term of the document make it abundantly clear that when a suspect signs them, he or she does so in order to acknowledge that he has been notified of his or her rights and he understands them. Paragraph 40, the practice whereby these documents are completed merely satisfies the prosecutor that the suspect may now be taken to court is to be frowned upon and not condoned by this court.
And it's a senior judge. It's a senior judge who says that.
Yeah.
Oh, it is.
Yes, ma'am. It seems that notice in terms of the Constitution is completed before the person is accepted into the cells, but merely as formality and for no other purpose. The warning statement is also completed merely as a formality that is required for administrative purposes or as part of the paperwork, but not for the intended purposes. As previously stated, mere lip service is paid to the rights embodied in the Constitution as detailed in the documents. They are significant in determining whether an arrest or subsequent detention are lawful or not, can never be overemphasized. My submission, my lord, to this court is that this form, it does not, my lord, necessarily say it must be completed when the suspect is charged. But this form says, as I've read it into the record, it must be completed whenever there is an interview between
Who must complete it?
It must be completed by the person interviewing the suspect.
By the police person? Eh?
By the police person, yes, my lord. Interviewing the suspect. If I can go further, it even says the number of the people who were present during the interview should also be recorded. My lord.
Have you read Preller's remarks?
No, my lord, those are my submissions.
Yeah, fine. No. I want you to
Yes.
listen to what Preller said, because you brought this judgment.
Yes, my lord.
This was a 3-bench judgment. Preller was the senior judge, Manamela acting, and Kumalo was the other judge. But this is what Preller said. Manamela was the scribe, and the 2 judges overruled him. I have had the benefit of the judgment of my learned brother, but reluctantly find myself unable to agree with the conclusion to which he has come. The evidence was comprehensively dealt with in the judgment of the court of co, and there is no need to repeat it here. Suffice it to say that there were no misdirections in the judgment, and nor did counsel argue to the contrary. The main problem in this appeal arose from the remarks perhaps inadvertently made by the court of co in its judgment on the admissibility of certain crimes as to his co-accused. It is therefore clear that the court was well aware of the constitutional rights of the 5 accused and the discretionary nature of the exclusionary rule contained in section 35(5) of the Constitution. The subsection reads, evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise detrimental to the administration of justice. The prohibition is against the admission of evidence obtained by a process that violates the constitutional rights of the accused. That means only that if the accused person has, for example, been tortured or assaulted in order to force information from him, that information must be excluded. No finding to that effect was made in the judgment. The rule does not mean that any improper conduct, even if unconnected to the making of the statement, results in the exclusion of the evidence. That would be an application of the controversial rigid exclusionary rule of the North American law. I think it's State versus Ross, that case. The trial court is the primary trier of fact, and this court can only interfere with the finding if we are satisfied that it is wrong. A vague suspicion that all was not kosher and is not enough. Unfortunately, we don't know how exactly what the learned judge had in mind with this remark, but the fact is that he considered every detail of the relevant evidence very carefully and came to the conclusion that the evidence should be admitted. In the process, he expressly rejected the contentions of the appellants that they had been tortured, as well as their evidence that they had made the statement and done the pointing out under it. Somebody interfered with it. Where's the 4th page here? Somebody removed it. Is that page 4? Can I have page 4? Thank you. Yeah, and then paragraph 92 reads, it's page 4. One of the main contentions No, I'll still read page 19. Paragraph 88, sorry. He says, it is not necessary to set out the evidence adduced in the court below, as Manamela AJ has done in some detail in his judgment. My view and position in the matter is informed by the approach advocated by the court in Take and Safe Trading CC versus Standard Bank of South Africa 2004-1 or South Africa SA 597 SCA 2004, where it was stated, a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake made by the other side, and the judge's position in a criminal trial is not merely that of an umpire to see that the rules of the games are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. Every person is ensured a right to fair treatment as a suspect and a fair trial as an accused by the Constitution. Section 35 commands that arrest processes and criminal trials be conducted in accordance with the basic principles of justice and fairness. To guarantee the protection, subsection 5 thereof makes provision for the exclusion of evidence that has been procured in a manner that violates any right of the Bill of Rights, if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. To ensure a fair trial, a presiding officer or judge may therefore only consider evidence obtained legitimately to establish whether or not an accused is guilty. However, in terms of subsection 5, if the admission of the evidence would not render the trial unfair or detrimental to the administration of justice, even though it might have been in a manner obtained in a manner that violates a Bill of Rights, it will not necessarily be excluded. Therefore, not every violation of a right protected by the Bill of Rights leads to exclusion. See in this regard, S versus Ndlovu and others, 2002, SCA, ZACA 70, 2002, 2 SACR 325 SCA. The section does not couple the discretion to exclude directly to the violation of a right as argued on behalf of the applicant, but to the consequential unfair trial. Therefore, the jurisdictional prerequisites for the exercise of the discretion to exclude is a requirement of unfairness or the prejudice to the administration of justice. What the subsection accords are fundamental and absolute is the right to a fair trial. In S versus Tandwa, 207 SCA 34 RSC 8, Cameron 116 observed the pre-constitutional approach to the exclusion of improperly obtained evidence to be in these terms. The noble feature of the constitutional specific exclusionary provision is that it does not provide for automatic exclusion of unconstitutionally obtained evidence. Evidence must be excluded only if A, it renders the trial unfair, B, otherwise detrimental to the administration of justice. This entails that admitting the impugned evidence could damage the administration of justice in ways that could leave the fairness of the trial intact, but where admitting the evidence renders the trial itself unfair, the administration of justice is always damaged. Differently put, evidence must be excluded in all cases where the admission is detrimental to the administration of justice, excluding the subset of cases where it renders the trial unfair. The provision plainly envisages cases where evidence should be excluded for broad public policy reasons beyond fairness and individual fairness and of the accused. Kachalia in S versus Mtombo said the following: public policy in this context is concerned not only to ensure that the guilty are held accountable, it also is concerned with the propriety of the conduct of investigating and prosecutorial agencies in securing evidence against criminal suspects. It involves considering the nature of the violation and the impact that evidence obtained as a result thereof will have, not only on a particular case, but also on the integrity of the administration of justice in the long term. Public policy, therefore, sets itself firmly against admitting evidence obtained in deliberate or flagrant violation of the Constitution, if on the other hand the conduct of the police is reasonable and justifiable, the evidence is less likely to be excluded, even if obtained through an infringement of the Constitution. This accords with what Krichler said in the case of K versus Attorney General of the Transvaal, 1996 Constitutional Court case, where it says sometimes even unconstitutionally obtained evidence, because of the demands of public policy and the demands of fairness in the administration of justice, may be admitted, even if you're aware of the case.
Yes, ma'am.
So this case of Hodis is not the be-it and the be-all.
As the court pleases.
I've quoted you two constitutional cases
As the
where they say even unconstitutionally obtained evidence. Do you have that? Hello? Key, Attorney General of the Transvaal. Let's read it so that everybody knows it. Right? Do you have it?
Yeah, I'm just finding it quickly, my lord.
Yeah, just find it. Yeah, you've got Mr. Computer. So the case has to delve into the intricacies of public policy, the fairness, etc. And this, according to me, this form has got no force of law. Do you agree with it?
As the court pleases.
Yeah, it has no force of law. It's a guideline. But I'm not stopping you from arguing. You can argue that. I'm just saying preliminary. Where's that case?
Oh, my learned friend is finding it.
No, man, just find it. Mr. Baloyi,
As the court pleases, my lord.
you're still under oath, Sergeant?
Confirmed, my lord.
My lord, yesterday the state referred to Exhibit VV in brackets 1.
VV.
Yes, VV in brackets 1. It's a dental report.
Right, yes.
Compiled on the 22nd of June 2020, just before our journey yesterday.
Right.
Advocate Mngomezulu stood up and indicated that the reason why they handed up this dental report was only to refer to the date of the 22nd of June 2020 being the date of the examination.
He says the only reason why they hand up,
The dental report.
yeah, it was to indicate.
Was to indicate that that accused number 2 was examined
Yeah,
by a dentist on the 22nd of June 2020.
right.
But my lord, that came after the state had re-examined the witness on the contents of Exhibit VV1. So basically the boat had already sailed. This morning we reached an agreement, my lord, that to resolve this list between the state and the defense, the dentist will be called in due course.
Yeah, but I have evidence before this court. You can call the dentist, but the evidence I have here is of the report, which is consensual by consent of
Yes.
both parties
Yes.
handed up. Am I?
Yes, Section 213, my lord.
Yeah,
That-
am
that-
I?
Even if we did not expressly say so,
Yeah.
that was the import of the
Right, and there was no
handing
addendum
up. Yes,
or any explanation
yes,
that this document is handed up for the limited exigency of the date of the 26th of June.
yes. Indeed, that is the position, my lord.
Because this was an examination which was prompted, as I understood the evidence, by this witness when he took the accused number 2 to the dentist.
Yes.
Is that not so?
Indeed. In fact, they put it to a witness that the accused did not appear in court on the 22nd of June.
Yeah.
And to buttress their point, they then handed up this document to show that he was examined by a dentist on that day.
Right. And after that, you led evidence about the examination, alleged examination, which was undertaken by this doctor.
Yes, indeed.
But the gravamen of the matter is that that report is before this court. Is that not so, Mr. Mngomezulu?
It is so.
Yes, it is before court.
Do I have to make submissions on it?
No, you
Or is
can.
it the only question the court asked?
No, I'm not asking you. I'm saying, as far as I'm aware, this report is ended up lawfully and it is before this court. That's all.
But my lord, we have made an agreement. We have
That
made an
agreement doesn't bind the judge. You know that. You can agree with Mr. Balui to go to the moon. It doesn't bind this judge. This
My
judge
lord-
is bound by evidence.
My lord, may I, with your respect, address this case in this manner?
Yes, sir.
The state has submitted that the purpose for handing over the document was for the defense to demonstrate that accused number
The state has argued that.
just submitted now, confirming what I've used the statement for that reason. The contents of the document
Yeah.
was not alluded to
By whom?
by the defense during cross-examination. We only dealt with the date, which is, I would submit, is the evidence aliunde outside the contents of the document itself, because the defense intended to demonstrate the alibi defense to say when the state alleges that accused number 2 attended court in Shabani on that particular day. So our alibi to that effect is to say accused number 2 was consulted with the dentist. So the contents and everything contained in the docket was never been an issue to be clarified from the witness.
Yeah. So your submission is the document can be headed up holistically to this court, but this court must just peruse
May
a
I?
minuscule part of it, the 26th of June. The other information which was elicited by this gentleman, who is the state prosecutor, I must ignore that.
No, my lord, I said, let's look at the nature of the evidence.
Yes.
I submitted that it's evidence aliunde, it's outside the document itself, because it only bears the date, not the contents of what was accused number 2 examined for.
You want us to play the record back? Mr. Baloi led this evidence. Where's that document? Let me just look for it. Mr. Baloi placed the contents of the document on record. Am I correct, sir? Everything. There's no evidence aliunde. Everything was placed by Mr. Baloi on record. Let me just get it. He said this witness must read the heading. He read the heading. I remember it's Bafokeng, CHC, etc., etc. He even elicited evidence about the number of cavities and the dental structure of that your client. He elicited it. So when you say it's aliunde, it can't be correct, sir.
My
Please.
lord, may I just indicate that
Sorry,
this witness...
wait. Where's the? Just give me a copy of that. Because the papers are being messed up. Is that the witness's copy? How much you copy it?
Yes,
Okay, sorry.
mine has got notes.
No, right, I've got it. For instance, the following evidence was put on record. Complainant, patient requests an examination for oral cavity, dental history, extraction of health questionnaire. Do you present or have you previously suffered from any of the following allergies? Rheumatic fever? No, he put it on record, not me. Venereal disease? No. HIV/AIDS? No. Lung disease? No. TB? No. Are you on medication? No. Smoking? Yes. And then it goes. Rheumatic fever? No. Psychosomatic disturbances? No. Pregnant? No. Viral infection? No. Epilepsy? No. Diabetes? No. Liver, kidney problems? No. Hypertension? No. Asthma? Yes. The patient reports to have been admitted for a heart condition. This is the doctor writing. In 2014 following a mining accident, and it is signed. And Mr. Baloyi also went on the other side and said to this witness, can you put the following information of the clinical examination on record? And he called it a general appraisal. TM joints, lymph nodes, intraoral exam, lips and buccal mucus, oropharynx and tonsils, palate, he even said palate, remember that, floor of mouth, tongue, gingival and periodicum, angle classification, teeth chart, interdental spaces. He even said it's 11, 12, 21, 22, 23, and then conlingual recession, 41, 42D. All this information was placed on record. Sir.
My Lord, may I make a following submission?
Yes.
We never agreed with the state in relation to the contents of what is before this lordship. My Lord, that is a copy in the first place. What I've canvassed to the state, I requested to see the original of that document because a copy cannot be handed to the court. Primarily, we want to establish the authenticity of the document. Secondly, if we did not agree on the contents, then the author of the document must be called to testify, to lay the basis upon which he or she made that finding. Number two, the witness concerned, based on the contents of that statement or of that report, cannot explain. He has no medical background. So the person that we as the state agreed to call is because, firstly, when I asked for the original document to compare with that.
But you know what? All this comes now. You never said all of this yesterday when you were leading your client and when you were cross-examining this witness. You never said.
My Lord, this thing came after when.
Yeah. So don't make me like I'm a judge who doesn't listen. Never canvassed any of this information. Never. You never did. And now you're canvassing it even without a leaf of this court.
My Lord, may I request that the court incline to our agreement with the state.
But it doesn't bind me. That's what I told you. Can you show me any law which says an agreement between the state binds the court?
No. I don't want to go insofar as that is concerned, my Lord. But with from your assistance as the adjudicator in this matter, if the parties so agree to, as prescribed.
I have not said I am not allowing the parties to agree to call the doctor. I never said that. Never. You can call the doctor. No. I can't stop the state calling a witness. I don't have that might or capacity in terms of the Criminal Procedure Act. That's why I say, you and him, if you agree on whatever, fine. But I am bound by what was led in evidence in this court. That's all I'm saying.
And my Lord, I wish your Lordship to take cognizance of the fact that I wouldn't be in a position to cross-examine again the witness, because that aspect was raised at the time when the state was examining the witness. We request your indulgence, my lord, to get the original document first and for the doctor to be called to confirm the contents of what is contained in the dental report.
Is this in pursuance of a fair trial, this application?
That's my submission, my lord. That would be fair.
Mr. Are you finished? Mr.
I'm done.
Mr. Baloyi, there's an application.
As I got this, my lord. The defense handed up the document. They approached the state and said, can we hand up this document? And we agreed. And they wanted to use the document which they used, but now that it appears as if it's to their disadvantage, now they want certain portions to be disregarded. It doesn't work that way, my lord. Once a document has been handed up by agreement, it binds the parties. We submit, my lord, that the defense cannot now make a volte-face and say, but we only handed the document just for a specific limited purpose.
No, that is not correct, because I was in court, I was listening when you were leading this witness to read what is written on the report.
Yes.
And there was no objection from Mr. Mngomezulu. No objection. Niggies.
In fact, they read part of it in the record.
I know.
Yes. But
anyway, are you opposing that application?
Intimated on the strict basis of the law, my lord.
You are opposing it?
We oppose it.
Fine. You can call that witness. I don't have a problem. Any response, sir, before I make a ruling? Mr. Mngomezulu? Yes.
My lord, I stand by my
Okay.
my submission.
Fine. Yeah. There's an application by Mr. Mngomezulu on behalf of the applicant, of Mr. Ntanzi, accused number 2. And this relates to the fact that after the evidence, which is encapsulated in Exhibit VV1, which was handed up to this court by 2 officers of this court who told this court that they had agreed to hand it up. And they even agreed that it should be marked Exhibit VV1. And it was duly marked. And this witness was led on the contents of this very document. Cross-examination was conducted by Mr. Mngomezulu in relation to some aspects of this document. Now, this court is seized with this document. The state is opposing the application for the retraction and the recantation of the contents of this document. And Mr. Baloyi says, on a point of law, the state is opposed to that. And I ask pertinently Mr. Mngomezulu whether he wants the retraction of this document purely because of the exigencies or the requirements of a fair trial in respect of his client. He says yes. I'd like to differ with Mr. Mngomezulu, and these are the reasons. In the case of the National Director of Public Prosecutions and David Cunningham King, it's case number 86 of 2009. It was an appeal from the judgment of Mr. Busielo, the former clerk of mine, who was in the Supreme Court of Appeals. he wrote the judgment against which there is an appeal. The judges who presided on this application of appeal is Haramse, who was the deputy president of the Supreme Court of Appeals, Nugent, Mlambo, Malan, and Majid. And this is what they have to say about an exigency like this, where evidence is now sought to be recanted when it was formally and lawfully admitted into this court. If you want to read this decision, you can read about it. It's about this billionaire who was avoiding tax, King. And they took him to all the courts, right up to the constitutional courts. This judgment actually landed up in the constitutional court. But it concerns the basis of what is a fair trial. In paragraph 4, describe Harams has this to say: it is well to remind ourselves at the outset of a number of basic principles in approaching the matter. Constitutions call for a generous interpretation in order to give full effect to the fundamental rights and freedoms that they create. The right to a fair trial is, by virtue of the introductory words of Section 35(3) of the Bill of Rights, broader than those rights specifically conferred by the fair trial guarantee therein, and embraces a concept of substantive fairness that is not to be equated with what might have passed muster in the past. This does not mean that all existing principles of law have to be jettisoned, nor does it mean that one can attach to the concept of a fair trial any meaning whatever one wishes it to mean. The question remains whether the right asserted is a right that is reasonably required to a fair trial. A generous approach is called for. This is the question for the trial judge, and there is, in general, not an a priori answer to the question whether a trial will be fair or not. Potential prejudice may be rectified during the course of the trial, and the court may make a preliminary ruling depending on how the case unfolds, and may revoke or amend it, like I did yesterday. Irregularities do not lead necessarily to a failure of justice. There is no such thing as perfect justice, a system where an accused person should be shown every scintilla of information that might be useful to his defense, and discovery in criminal cases must always be a compromise. Fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's right should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of a fair trial provision is not to make it impractical to conduct a prosecution. The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems like here, or to encourage preliminary and pervasive litigation. In this judgment, these 5 judges, senior judges, I must say, they quote the case of S versus Sheikh, 2002 SA 208 cc at paragraph 43, and the case of State versus Basson 2003 3 SA 582 Constitutional Court at paragraph 120. And there is an addendum that an allegation that an interlocutory ruling was wrongly made, which may have a material impact on the outcome of a case like this one, is not sufficient to demonstrate that the trial was unfair. They also cite the case of R versus Corner, 1995 4 SACR 411, paragraph 139, 185. They also cite the case of Montgomery and His Majesty's Advocate General and another, 2003 1 AC 641 PC 673. This is a British High Court case of Lords by Lord Hope of Craighead Coating Pillar versus United Kingdom 22 EHRR 391. They also caught the case you read yesterday, Key versus Attorney General, Cape Provincial Division and another, 1996 for SA 187 CC, paragraph 13. And they also quote the case of Zuma versus the Director of National Public Prosecutions and others. I've got all the judgments here. I don't have to read them. If you want to read them in adumbration of one I've already read, be my guest. But the application, Mr. Mngomezulu, is not acceded to. It is dismissed. But having said that, you and your colleague, you can call any witness you want. But the application to exclude this evidence, which was formally tendered in this court, is refused because it's not in the interest of justice. And this gentlemen, 5 of them, make it obvious that a right to a fair trial is ambidextrous. It's not only for the accused, it is also for the state and the public, which is represented by the state. Because there's an assumption in South Africa that Section 35(5) applies only to accused persons. No, the corollary, when you understand the law, is that what should happen in Section 35 should also happen in respect of the presentation of the case of the state. It's not a one-way traffic, as they say. Okay, yes, Mr. Bale.
Sergeant Mokhani, counsel for accused number 1 and 2, put the following proposition to you regarding the events on the 18th of October 2020 at the workplace of accused number 2 at Sibanye Stillwater in
18 June.
Yes, 18 June, I'm sorry. Oh, I'm sorry, 18 June 2020 at Sibanye Stillwater in Carltonville, that after Brigadier Gininda and Sergeant Mohola had departed, you asked accused number 2 for directions back to Rustenburg. He thought that you were satisfied with the explanation that is regarding his whereabouts on the 26th of October 2014, and that you're going to release him.
Mwelele wa molatofatša wa pele le wa bobedi ba ile ba bolela le lena ba le botša gore ka di 18 tša June 2020 be be le mola Sibanye Stillwaters lena ka moraga gore monna Gininda a sepela le mogola lena le ile la botsha molatofatšo wa bobedi tsela ya gore le boela jwang morago go ya Rustenburg ke mo eleng gore molatofatšo yena o be a nagana gore lena le setse le kgotsofetse ka dilo ka moka tše e leng gore le be le di khumane gape le be le tlo molokolla
Neli kamsolwa uqala lesibili uthi ngomhla ka-18 kuJuni lapha esenza khona umsolo wesibili esibhayini Stillwater eCarltonville uthi emva kokuthi-ke uGininda noSergeant uMkhula behambile wena wabuza ukuthi indlela eya eRustenburg ihamba kanjani wase-ke ngaleso sikhathi besicabanga ukuthi ubuziswa ukuthi vele hayi kusonelisekile ngakho konke okwenzekile enokuthi-ke emva kwaloko uyomkhulula.
Your response was, when we left the mine yard, we had evidence that accused number 2 was not at work and that we parked outside the premises and he had a conversation with Brigadier Gininda.
karabo ya lena le rile gešitše le tšwa mola merafong lena besitše lena le bohlatse ba gore molatofatšo wa bobedi o be a se mmerekong gape lena le be le pakile ka ntle.
Kuthiwa-ke lapho-ke masele nelisekile umsotho wesibili wayengekho emsebenzini ngalelo langa nase ninaye niphaka ngaphandle uBrigadier Gininda wasekhuluma naye.
Now, except for the cloaking records of accused number 2, was there anything else that was shown to him by Brigadier Gininda?
Biale ka ntleng ga di-record tšela tša ge tša go tloka tša molatofatšo wa bobedi go na le dilo tše dingwe tše e leng gore mohlomong lephodisa Gininda le ile la mmontšha tšona.
Ngaphandle kwale koma-record okutloka emsebenzini khona uGininda amkhombisa khona umsolo.
Ekugopola lera from our side.
Are you referring from our side?
Yes.
No, ready to know village fella ka
I do not want to respond on what I do not remember
just
correctly on what happened.
Just to rephrase, you mentioned an identity kit. When did that where did that incident take place regarding the identity kit?
Go le gopotsa lena le la bolela ka identity kit. Taba ye we e be e diragetse ning.
Khulume nga-identity kit leko kwenzeka nini?
Okay, gopola bjale nako le re le ka mo ntle ga mine before re tlo tsamaya.
Now I remember, my lord, that happened whilst we were outside the mine before we left.
Sengiyakhumbula manje lokho kwenzeka ngaphandle kwemayini singahambi.
So when accused number 2 approached, or when accused number 2 indicated that he wishes to speak to Brigadier Gininda, that was after the cloaking records had been consulted and this ID kit shown to him.
Molatofatšo wa bobedi yena o be a rile o kgopela go bolela le ntate Gininda ka moraga gore the setse ba mmontšhitše di-cloaking record le ID ntho we yena kit yela. It is correctly so, my lord.
Manje umsolwa-ke semuva ukuthi-ke kweneliseke ukuthi bamkhombise ama-cloaking record akhe baphinde bamkhombise-ke nale-identity kit.
Now, regarding the events of the 19th of June 2020, the day on which accused number 2 made a confession to Lieutenant Colonel Rapadu at Moroka Police Station.
Jwale ditaba tša di 19 tša June 2020 ge ne molatofatšwa a ilo bolela ke bolela mo pele ga lephodisa kwa Moroka Police Station.
Well, because 19 of June,
It was put to you that you were traveling in a Toyota Fortuner.
lena ba ile ba le botsa gore le be le sepela ka Toyota Fortuner.
Sure, Bohamba, if Toyota for sure.
That is correct.
Do you remember its registration number?
Le sa gopola gore number plate ya yona e be e reng?
FV
FV
47
47
LRGP.
LRGP, my lord.
The number plate that FB47 LRGP.
Do you know if this vehicle is fitted with a tracking device?
Le a tseba gore koloi e we e be e loketswe tracker na?
Rena re bitsa AVL.
Yes, and we refer to it as AVL.
Manje ayina moto na tracker kodwa isensibiza ukuthi AVL.
What does AVL stand for?
Ye emetseng e
For
AVL le
record
bolelang ka
purposes.
yona?
Automatic vehicle location.
Automatic vehicle location, my lord.
We show automatic vehicle location.
And what purpose does it serve?
E shoma go dira eng?
E kgona gore tshireletsa gape le gore bontšha ona re sepela kae le kae re dira moshomo wa rena.
It is able to protect us and to also direct us on where are we driving as we are conducting our duties.
Yasivikela nokukhomba ukuthi besihamba masibe usenza umsebenzi wethu.
And the witness would still like to proceed, my lord.
And gape le go bontšha koloi le gore ya botsuiwa re kgona le go e lebelela ka yona AVL.
And to also show if the vehicle is to be stolen, we are also able to see through the AVL.
Kuthi-ke imoto intshontsha siyakwazi ukubona ngayo le AVL.
Now, counsel for accused number 1 and 2 put it to you that on your way to Moraka police station, you took a detour and stopped at a filling station near Alberton, where accused number 2 was assaulted. Will this be reflected in the records of the AVL?
Judge, moleledi wa molatofatso wa bobedi yena o rile ge ntse le sepela le ya Moraka police station le na le ile la fapoga la tsena mo e leng gore le be le ile tshela petrol gona mo Alberton mo la petrol station mo molatofatso a ileng a bethwa seo se tla kgona go bontshana mo yona AVL yena.
In other words, if there was a deviation in the route that you had to follow, would that be reflected in the AVL records?
Mola ge le na le tswile tseleng e be le swanetse le latetse e tla kgona go bontsha go yona AVL yeo.
Manje kuthiwa ngesikhathini ya eMorocco nathi esuka nahamba naye endaweni yase-Alberton naseGarage afika msola waphi noshawa khona manje umbuzo ukuthi-ke lokho kuzokhombisa yini kule AVL yena.
Itla bontšha.
Yes, it would reflect, my lord.
Yebo izokhombisa.
Yes. It was put to you that when you deviated and stopped at a filling station, accused 2 was taken out of the Toyota Fortuner and brought to Mr. Jonathan's vehicle, that he was made to sit on the right side of Mr. Jonathan's vehicle, and Sergeant Mabena was on the left, and Buthelezi was on the right at the back, and that Sergeant Mabena used a silver-colored two-weights plastic to suffocate the accused, and that Buthelezi was blocking accused number 2 from leaving the motor vehicle, and that the accused was assaulted, and that you moved away from that place after this assault to a dumping place near Alberton at an industrial area.
Ke taba e telele ye mo e leng gore ba re molatofatso o ile a ntshiwa ka koloing ela e be le sepela le yena ka go yona a lokelwa ka koloing e leng gore e be e na le Jonathan le Mabena le Buthelezi yena a lokelwa ka leska ka seatleng sa go ja mo e leng gore Mabena yena o ba le ka seatleng sa lenyene Buthelezi yena a tšea plastiki ya truwords a lokela molatofatso sefatlhogong ke mo e leng gore o ile a bethwa ka moraga mowe le ile la tloga la ya mola mo go latlhuwang dilo gona
In other ways, that the accused was assaulted in your presence.
Se se bolelang gore molatofatšwa o bethilwe lena le le gona. Even today, my lord, I'm still declining that that never happened.
Okay, umsolo yetwa kisho motweni yakho isho motweni ehamba uJonathan umabhena yakho ngaphakathi nokuthelezi to umthelezi wakhipha iplastic yakho le ayifaka ekhanda likamsolo and futhi ke umthiwa umabhena yena wemvalele ngale kumnyango ukuthi angakwazi ukuphuma and kuthiwa kwaqhubeka kuchawa khona umsolo lapho waphila.
And there at the dumping place on the way to Alberton, that the accused was handcuffed to a steel pipe. He was further assaulted.
Gape ba re molatofatšwa mola mo go latlhiwang dilo gona ke mo e leng gore molatofatšwa o ile a bethwa ka pipe ya tshipi.
And later on that Brigadier Gilinda arrived, but it was put to you that you did not participate in the assault there at the garage or the steel place. It was put to you that you moved away when the accused was assaulted. You came back there at the steel place and said they must stop assaulting the accused. It was put to you that the words were used to Yekelani Diman.
Ba re ge ke mo e leng gore lena ba re ga seng ke lebe karolo ya go betha moisaoki gape go ile go tswelwa pele a bethwa go fitlhella lena le be le botswa mantswe a gore lesang moisao.
Was the accused ever assaulted in your presence there at, as alleged by the defense, at this steel place?
Molatofatšwa o ile a bethwa na lena le le gona mola mo tulong ela ya ditšhipi. I do not recall him being assaulted.
And
that from that point, it was put to you by Counsel for Accused 1 and 2 that you proceeded to Chris Hani Baragwanath Hospital, pick up Colonel Rapadu, and went to in Orlando where there were disused machines where the accused was further assaulted in your presence.
Gape ba re go tloga mo ke mo e leng gore lena le ile la ya sepetleleng sa Baragwana ke mo e leng gore le ile la tšea lephodisa Rapadu gape la tswela pele la ya Orlando ke mo e leng gore molatofatšwa o ile a bethwa gape le ntse le le gona.
Now
lapho wena asuka na isibhedlela sase Baragwana San Baragwana lana thatha khona uKolonel Rapadu na indawo ekhasha khona indodana ngase Orlando la qhubeka khona washaya umsono.
Now, were there any charges laid that an assault took place in your presence and that you failed to stop such an assault?
Go na le melato e leng gore ile ya bulwa na ya gore motho o bethilwe le le gona lena le paletswe ke gore le thibe ge be motho a betho.
Anje khona icala ine lavula lokuthi wena ukhona isikhathi eshaya umsono.
Awu.
No.
Or any disciplinary proceedings put in train for the fact that you failed to stop an assault in your presence?
Go ba motlhomong megato e tšerweng mmerekong ya gore lena le paletswe ke go thiba motho a bethwa.
Nokuthi khona inyathelo ezathathwa emsebenzini wakho ukuthi wena awuzange ugweme ushawa kukamsono.
Awu.
No.
Cha akukho lo.
You mentioned further in cross-examination by counsel for accused number 1 and 2 that you did arrange escort on the day, the 19th of June, 2020. Now, what is the position when you are being escorted? Are you allowed to deviate from the route?
Judge, lena le ile la re ka di 19 tša June le ile la kgopela gore le tle le be le batho ba ileng gore ba sepela le lena ba le lateletse. Judge, motšhotšhisi o nyaka go tseba gore le dumeletswe na gore le fapoge tseleng ge le na le batho ba e leng gore ba sepela le lena ba le latelela ka morago.
Manje banile abantu abanipindezelayo niyavumela yini ukuthi niphezuke endleleni?
Awa.
No, we are not allowed to deviate, my lord.
Cha asivunyelwana. My lord, may I request a comfort plea?
Yep. Are you proficient? Oh, Mr. Jonas is all right.
As a court, please, my lord, the state is going to canvass the AVL report with the witness. The copies were given to the defense on Friday when we received the report, my lord.
Wait. You say there is a report.
Yes.
What you call it? What? An AV?
It's an AVL report, automatic vehicle location report, that shows the movement of the vehicle in question.
Sort of a tachograph.
Indeed, my lord.
But you say you have a report. Has it been disputed?
Well, it was handed to the defense on Friday.
Yeah.
They haven't really indicated what their position is.
No, they must indicate, because as I recall, evidence of a technical nature requires an expert to adduce that evidence. You can lead that evidence through this.
Yes.
But if you say it's a report of a mechanical device, are you going to call the expert?
Well, it just shows the location.
Oh, okay, fine. Okay.
Yes.
But is it being disputed by Mr. Mngomezulu? Are you objecting?
I'm objecting, my lord.
Right. Mr. Munisi, are you objecting?
I'm just receiving it now. I think it's 30 seconds ago.
30 seconds ago.
Yeah.
Mr. Ngumalo,
My lord, it is
10 seconds ago.
It is evidence of a technical nature. I don't understand what is written here.
Technical.
Yeah, it's too.
You have never heard of evidence of a technical. I don't charge much for classes, you know.
Yeah, it's technical. I don't understand, my lord, what is written.
Okay, fine. What do we do if they say they want to prepare and they are opposing, and you want to canvass it with this witness?
As a court, please, my lord, I personally brought this document to the defense on Friday.
No, Mr. Munisi,
The
sorry,
court,
30 seconds ago.
no, the court will recall we adjourned early on Friday. I personally came to court, gave each counsel a copy of the report. They were consulting here with the accused.
So they got the report on Friday.
Yes. Immediately when we received it, my lord, we shared it with the. I brought it personally to them here in court.
My lord, may I just make the following submission? During examination in chief, this evidence was not led.
Yes, I'm aware of that.
Yes. Now the state wants to reintroduce new evidence.
Yes.
I believe it's not going to be fair, because we must also cross-examine the witness. That means the state wants to reopen for us to cross-examine the witness, because
Yeah.
we don't admit the contents.
Yeah, he's going to. He knows that. He knows the law. He's going to bring an application. So, what do you intend doing, Mr. Baloyi?
As the court please, my lord, it was put to Sergeant Mokhani in cross-examination that he took a detour, stopped over at the filling station, stopped over at an industrial area in Germiston, stopped over at Chris Sani Baragwana Hospital, and also stopped over at Orlando, where there were disused machines. They put it to the witness that he was using a Toyota Fortuner. The witness has just testified that it's fitted with a tracking device. And if there's objective evidence, my lord, that can assist in the resolution of this issue, and we must mention that it's something that cropped up in cross-examination, that the witness deviated from the route. we submit, my lord, that if there's objective evidence that can help to resolve the issue, that evidence should be allowed.
Are you ready to argue the contrary, all counsels, or do you want to prepare? Let's start with Mr. Mngomezulu. There's an application. Do you want to prepare to oppose it, or what is the position?
We have, my lord, I'm not ready at the moment.
You want to prepare?
I want to prepare, but before I give another counsel, I need some clarity in terms of what the state has just informed the court or submitted to the court about this piece of evidence on the road that the defense suggested that they were taken from that filling station up to Orlando.
Yeah, they stopped, according to the version, if I recall it, they stopped next to a filling station. In Alberton, there's a board which says Alberton, there's a filling station. Then the accused two was then transferred into Jonathan's car, placed on the back. He maneuvered the seat to injure his ankles. Mabena was on the right, that evidence. And after that, the convoy left to a dumping place where there are still piping. The beating continued, and thereafter, during that beating, one of the handcuffs of the accused two was loosened, and he was connected to a pipe and beaten again. And after that, the convoy left towards Orlando. Paraguanath, Orlando, then was beating in the dumping place. Now this gentleman says he's got evidence to counter that. Are you saying that, sir? Hello?
Indeed, my lord.
That's what he says. He says he's got a tachograph. He calls it an AVL.
My lord, the purpose for bringing this application is to rebut the version of accused number 2. But the whole issue about the movement of this witness and Mr. Mabena did not start at the cross-examination.
No, fine. It
doesn't started at examination in chief.
Yeah, fine.
Where this witness and Mr. Mabena drove to Bongani. That's the evidence of the destination that they are going to reach. But there were movement that were mentioned by the state during examination chief.
Mr. Mngomezulu, you are a seasoned lawyer. He wants to introduce new evidence.
That's correct.
And if you are going to object to it, tell me. You want to prepare or you object to it now? So too, Mr. Mnisi Numalo and accused number 5 counsel.
Can you prepare, my lord, to make submissions? I'm not ready now.
Until when? Until when? When do you want to make?
Maybe we can proceed after lunch. It's not going to be much.
Mr. Mnisi?
My lord, well, I've got the following submission to make. It will be noted that apparently, I'm not so sure to what extent this also have an impact on accused number 3.
I don't know.
Yes. The reason why I'm saying this is almost 5 minutes that have been handed with this document. The state says it handed to us on a Friday, but I'm receiving it now 5 minutes ago. As an officer of the court, maybe there's something that I can pick from the document that I can assist the court with.
Yes.
But if it has been handed to me 5 minutes ago, I'm not in a position to do that because I haven't gone through the document.
How long do you need, Mr. Mnisi?
I don't know, my lord, what this document consists of and my analysis of it, whether...
Mr. Mngomezulu is just an easy document. ABC.
Maybe
lunchtime, we should.
Maybe here an advantage of going through it, you see, because it does not seem from, it does not match from Mr. Mngomezulu.
So you need how much time do you need?
Let's try after lunch, man. I would go with what
Mr. Ngumalo?
I also propose that we start after lunch.
What's the time now?
If I can make this proposal, maybe we can let this witness stand down until tomorrow. There's a short witness who's waiting outside. Maybe we can then proceed with that witness in the meantime.
Okay.
And then adjourn after that.
You want to properly formulate an application.
Well,
I've listened to you, I've heard you.
yes,
But for record purposes,
we can simply amplify the.
yeah, me, I prefer written submissions, so that you can't say, yesterday he didn't say this, he said it when Mandela was still president. If there's a record, then you are able to say, here's the record. So are you going to prepare some short hits?
Yes.
All of you, some short hits.
Yes,
That's all.
That's until when, madam?
Now we can do it tomorrow because he says there's another witness, a short witness. So you can bring the application tomorrow, fully formulated, and then you also you can bring your responses fully formulated tomorrow. Because you are saying you want to come back at 2 o'clock, meaning that you don't want to take a lunch hour. Is that what you're saying, Mr. Newman?
No, that is not what I was saying.
So how many minutes do you have between now and 1 o'clock? How
Yeah,
many?
if we have to prepare ahead, I
Hello?
think
Yeah, how many minutes do you have? What's the time now?
it's 11:10.
So you have 1 hour, 50 minutes.
1 hour, 15 minutes. So
To
I think
prepare.
it will be short. If we have to prepare ahead, I propose that maybe we adjourn until tomorrow.
Yeah, tomorrow then.
Yes,
Okay.
thank you.
Okay, the application and its objections by councils will be heard tomorrow morning at 10. You are excused until then, Mr. Mofane.
Ntate Mogwane, go na le kgopelo e santseng ba e dire jwa tse swanetse ba ilo lokisha dipampiri ke ka mo e leng gore kgoro e re lena le a lokollwa le tlo boya gape go sasa le tlo tswela pele ka moraga gore ba dirile kgopelo ya bona le a kwešiša.
Yeah, ke a kwešiša.
Well understood by the witness, my lord, and he says he will be present tomorrow.
kunalolu daba ke ofishane oluzolungiswa ke mayela nale ncwadi emayelana nokuthi le moto babehamba ngayo yahamba imiphi imizila noma yahamba kanjani ngayo yalanga abameli ke bathi banenkinga naloko banikezwa ke isikhathi ukuthi balungiseleke lokho ukuze kube kusasa ufakazi lona uzodedelwa ke na umshushisi usunayo nje ufakazi ozothatha isikhathi esincane ekungaqhutshekwa ngayo yena ke ubaba umkhana uzobuya kusasa.
Yes, Mr. Mngomezulu?
My lord, may I request your lordship to remind the witness before he leaves about the dockets that we requested him to bring.
The dockets, eh?
Docket.
You remember?
Le sa di gopola.
Ke a le gopola.
Yes, I remember, my lord.
Ngiyakhumbula ke amadokotela
You remember?
ukuthi ngize nawo.
Mr. Baloyi, in the meantime, you must mark the report by the sergeant for court purposes.
Yes, it's already been marked exhibit MM in brackets 2, my lord.
You never marked it for mine. Did you mark it? Did I mark mine? No, I don't have. Actually, me, I don't have. The very person who authorized that
Yes.
the report should be made, I don't have a copy, even now.
Yes, if my learned friends don't have a objection, we can hand it up now, my lord.
No, why would they object? It's in the record. I expunged that ruling I made. I revoked it.
So is the court referring to the information?
Yeah, the information which the sergeant marked confidential.
Okay. So
It's not the one.
no, this
You
is
see,
something
we're
else.
talking at cross purposes.
Yes, I'm sorry, my lord.
Where's that information? Okay,
It
just
has already
remember,
been marked, my lord.
I need it. You say it's marked MM,
No, not this one. I think it's already marked.
already marked? What?
Exhibit WW.
Exhibit WW.
Yes, my lord.
Okay. Okay, Ndati, tlabana ka sana.
Go lokile, eh?
Tomorrow then.
Le lokolo jwa mokgalabje.
Sorry, were you ever a boxer?
Ba re salla ba boramatswetse.
No, le ke gym sa sekolo.
I used to train when I was in school, my lord.
Okay. Is that the document?
time, I'm requesting for a comfortable break.
Eh?
A comfort break. Just
Comfort
5
break.
minutes. Yes.
Where is your witness now?
He must be outside.
Yeah, now you can go. Comfort break. How long? How long, sir?
I'm told it's already.
Oh, it's a-
approximately that we can take a short.
Short agenda. Okay. Okay, 15 minutes is okay.
As the court pleases, my lord.
You're still under oath, Sergeant?
Le sa le ka fase ga kano ya gore le tlo bolela nnete nya. Confirmed, my lord.
My lord, yesterday the state referred to exhibit VV in brackets 1.
VV.
Yes, VV in brackets 1. It's a dental report.
Right, yes.
Compiled on the 22nd of June 2020, just before I adjourned yesterday.
Right.
Advocate Mngomezulu stood up and indicated that the reason why they handed up this dental report was only to refer to the date of the 22nd of June 2020 being the date of the examination.
He says the only reason why they hand up,
The dental report
yeah, it was to indicate,
was to indicate that that accused number 2 was examined
yeah,
by a dentist on the 22nd of June 2020.
right?
But, my lord, that came after the state had re-examined the witness on the contents of exhibit VV1. So basically, the boat had already sailed. This morning, we reached an agreement, my lord, that to resolve this list between the state and the defense, the dentist will be called in due course.
Yeah, but I have evidence before this court. So you can call the dentist, but the evidence I have here is of the report which is consensual by consent of
Yes.
both parties
Yes.
handed up. Am I?
Yes, section 213, my lord.
Yeah,
That-
am
that-
I?
Even if we did not express